Page number 2, serial number 6 to 14. Page number 3, 15 to 23.
Your Lordship, serial number 10 and 11, the council is from Chennai, has requested this matter for next Tuesday, Your Lordship.
We'll list the matter on
10
9th,
9
Tuesday.
outside. Huh?
9.
Oh, pleasure.
Can we have it on 10th? 9th list is long.
The council is from Chennai, Your Lordship. He has requested for Tuesday.
Objection sustained. Yes.
Oh, pleasure.
9. Page number 3, 15 to 23. 9. Page number 4, serial number 24 to 30. Page number 5, 31 to 37.
37 ಅಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಹಾಕ್ಬೇಕಾಗಿತ್ತು ಶಾರ್ಟ್ ಡೇಟ್ ಒನ್ ವೀಕ್ ಸರ್
Relist the matter on
10th.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಸೇಮ್
inform the other side.
Page number 6, 38 to 42. Page number 7, 43 to 48. Page number 8, 49 to 53. Page number 9, 54 to 60.
My lord, serial number 54, kindly have it after 2 weeks. 54.
At request, relist the matter after 2 weeks.
Page number 10, 61 to 67.
65, my lord.
65.
Yes.
Lords, you may have it next week, my lord. 65. I
Right.
inform the others.
At request, relist the matter on
10th.
Lords, interim order may kindly wait.
interim order earlier granted is extended till the next date.
Obliged.
Page number 11, 68 to 74. Page number 12, 75 to 76. Page number 13, 77 to 80. Page number 14, 81. Page number 19, 82 to 84.
My lord, sir, fresh GST matter. Next Tuesday, my lord.
Yes,
9th.
yes.
My lords,
That, just 1 minute. I'm still not able to understand that 40, 60 and 50. You please explain once more. Because if I don't understand, I still am not able to understand what do you mean by aggregate when you say 40 and 60.
I will.
And to theory, practical, just looking.
my lords, in GST, one intermediary batch was mentioned along with the serial number 83, which is listed today at 230, 83, 84. The batch where Raghuraman is engaged, senior counsel, that was mentioned last time to be listed today, but it's not listed. May I request the same to be listed so that it can also be argued on the same, along with the same batch?
My lord,
Tomorrow, there is a race in the matter.
Tuesday and Wednesday is only tax matters. Can take it on next Tuesday.
The recovery procedure is initiating, madam.
Correct, but on other days it won't reach because we have got other subjects. Tomorrow we have company.
Day after-
Huh?
day after tomorrow.
Day after tomorrow afternoon division bench, morning part heard matters. Let it come on Tuesday, we'll take it. When did you file it?
Last week-
You could have moved it for today, we would have got it. Yesterday, if you had moved, we would have got it. Tuesday.
my lord, serial number 84, that is regarding that Amazon matter, my lord, intermediate services. Now, my lord, they are reallocating all the files in view of the new panel that is this thing. I have informed the petitioner side that Shudas, sir. It may be taken after 4 weeks, my lord, or 3 weeks.
Your Lordship, we're not objecting for the adjournment, Lordship, but senior counsel is engaged in the matter. They want to make certain mentioning. So if at all, it can be mentioned at 2:30. It is
Fine, please.
grateful, Your Lordship.
Next one, fresh matter serial number 1. Chandrakant Argav.
I appeal for petitioner, my lords. The case of the petitioner is squarely covered by the decision of this honorable court in writ petition number 9721 of 2019, my lords. I was appointed as a class 1, I was working as class 1 contractor I entered into a contract with respondents on 19/6/2017, my lords. Meanwhile, the executive engineer,
No, correct. Now let the other side is not there. I'll pass over. It may not reach, or I'll have it on next Tuesday. Same stage.
my lords, notice may be directed.
Notice already issued.
No, my lords. It's a
But-
fresh
but
matter.
Appears, others are there, is it? Others are there. Land Council, Neem Kumar accepts notice for respondent number 1, 5 and 6. Okay. 9, 9, 9. Emergent notice to the 9th respondent, petitioners permitted to take out notice by way of hand summons as well.
Please, my lords.
And then we'll post it in the preliminary hearing list.
Please, my lords.
Is the,
Demand number three.
no, 4, 7 and 8, somebody is already appearing. Relist the meta and preliminary hearing list on 23rd.
Please, my lords.
Respondent number 2, who? Yes, yes. Yes. Next.
2, serial number 2.
Oblige, my lords.
Madhusudan UA.
See the password is.
It won't reach, Passover won't reach today.
No, my senior Mr.
Take a
Shankar.
chance, sir.
I'll take a chance, Your Honor.
Because 2:30 we have some other matters.
Please, Your Honor. No,
Huh?
he'll be here by 12 o'clock. It appears to be a short matter. I'll take a chance, sir.
Passover.
Please, oblige. 3.
My lords, I appear for the petitioner, my lords. This
Yes.
is also a 26 AS related matter, my lords, but I am here only on the short ground of principles of natural justice. I had filed my reply to show cause notice that has not been considered at the time of passing the order, my lords.
Learned Council, Arvind Chavan accepts notice for the
Respondents 1 and 2, my lords.
Respondent 1 and 2. Look into it.
My lords, interim order may be granted, my lords, in the meanwhile.
Now, what is the violation of principles of natural justice?
My lords, there was a show cause notice issued and I have replied to the show cause notice, but in the order original, the show cause notice has not been taken into
Point out,
record. And
point out,
personally-
point out.
Yes, my lords. In the, just a second. In the order original, my lords, reply
Yes,
to show
please.
cause notice, the noticee have neither submitted any written reply nor sought for time for replying.
Page, paragraph.
My lords, That's, I'm having some difficulty in the page numbering, my lords. It's annexure C, my lords. Annexure A, my lords. Annexure A, order in original. The third page in the order in original, my lords.
Or page 6 of 9, is it?
Yes, my lords.
Page 6
Page
of
4
9.
of 9, top of the page, my lords, reply to show cause notice.
Yes.
The noticee have neither submitted any reply nor sought for time for replying to the show cause notice, whereas I have filed my reply, my lords.
Annexure, where is
My
your
repl-
reply?
My reply is at annexure, annexure 6, my lord, annexure D, my lords.
Page?
I'm sorry, my lords,
Yes.
some difficulty with the page numbering, my lords.
Yes.
Annexure D, my lords.
Yes. Now, this was sent in the portal, through the portal or?
No, my lords, it was physically filed with a seal obtained, my lords, in the commissioner's office.
This was filed within the time
Yes,
prescribed.
my lords. Yes, my lords.
So then what is the interim relief you're seeking?
Just stay of the impugned order, my lords.
I'll state and have it in the preliminary hearing list.
Yes, my lords. It may be disposed of because it's
I'm
prima facie.
asking, yes, I'm asking Arvind, madam.
Yes, my lord.
Counsel for the petitioner submits that despite reply to show cause notice having been made, as is evidenced at annexure D, the order in original, however, observes that no written reply has been filed to the show cause notice. In light of the same, there would be a stay of
Annexure A, my lords.
annexure A till the next date. This is the matter in the preliminary hearing list
16.
16.
Copies, my lords.
Obliged, my lords.
Serial number 4. Tanmay Rajkumar, serial number 4.
Matter where I'm challenging a 263 revisional order and the order giving effect to the revisional order, whereby they're seeking to tax the compensation received for acquisition of land for BMRCL purposes, which is exempt in terms of section 96 of the Right to Fair Compensation Act of 2030. In fact, my lords, there is a direct decision of this honorable court on the point which decides the issue and holds that in view of section 96 of the 2013 Act, no tax can be levied on compensation received for acquisition. My lords, the impugned order, my lords, that annexure
The land,
H,
land acquisition act. Land acquisition act. Annexure,
annexure, in fact, my lords, annexure B, page 21 is the first assessment order, which was passed under 143(3). It was picked for limited scrutiny for examining this issue. Page 21, annexure B, my lords.
yes.
It was picked for limited scrutiny, my lords. Will see para 1. The case was selected for limited scrutiny assessment under reassessment scheme. One of the issues, my lords, is capital gains.
What do you
and
mean
income.
by limited scrutiny?
Limited scrutiny, my lords, there are two kinds of scrutiny. One is limited and another is complete. In the case of limited scrutiny, the system says that these are the particular issues which have to be checked by the assessing officer, and the assessment will have to be limited to those aspects. Therefore, these were the limited aspects that were picked, and this was the precise point that was examined by the assessing officer. In para 4, my lords, will see this issue was discussed. During the relevant previous year, assessee has not undertaken any trading or manufacturing activity. During the year, Special Land Acquisition Officer of KIADB Metro Rail Project had compulsorily acquired immovable property being land of assessee for compensation amount of approximately 14 crores. The assessee has claimed exemption for the compensation amount received by CBDT Circular number 36 dated so-and-so and the Act of 2013. During the course of assessment
Now,
proceedings,
after having accepted what has happened?
now the commissioner, in exercise of the revisional power under section 263, issued a notice. I responded to that in annexure C. Annexure D, my lords, is the order at page 28. There are, in fact, my lords, two orders. Annexure D, my lords, he says that I'm going to give you an opportunity of hearing. Please come and make your submissions by 12th April 2023. My lords, will see at page 28. My lords, will see first para, a hearing in the matter is fixed for 12/4/2023. This was, my lords, on 28th March 2023. Thereafter, my lords, the immediately next day, annexure E 29(3), an order is passed. Page 35, annexure E. The commissioner basically says that because the compensation is under the KADB Act, it is disbursed under the KADB Act, section 96 of the 2013 Central Act will not apply, and therefore that aspect has not been looked into by the assessing officer, requires re-adjudication by the assessing officer is the commissioner's order. My lords, will see
And yeah, that is on the merits of it.
that is on the merits of the matter. Para 4 is where the commissioner records his views. I have duly gone through the above submission of the assessee and facts available on record. In the assessee's case, the acquisition of his property was made by issuing a notification under 28(4) of the KADB Act and not under the Act of 2013. The compensation was determined paid to the assessee as per 29(2) of the KADB Act. As per Circular 36 of 16, compensation received in respect of award or agreement consequent to acquisition of property of a person has been exempted from levy of income tax, wide section
He
96.
says under this act.
So, my lords, this was the precise point that was examined by this honorable court. In Sri Balaji Corporate Services, which was upheld by the division bench, where they said that although the payment of compensation is in terms of the KADB Act, for the purposes of computation of the compensation, you go back to the 2013 Act, because this is an acquisition that has happened after the coming into effect of the 2013 Act.
Anyhow. So now it has to go back.
Malaj, it has to go back. Malaj, let them, Malaj, my submission is, Malaj, it's an appealable order on merits. They are, Malaj, just, it's covered by decision of this court, Malaj, they filed writ petition. Malaj, they can take up, challenge this order before the tribunal, Malaj, they can make the
It's
same
correct, it's a
submission.
legal question. What is the factual element to go in appeal? Now finally, we're sending it back to the revisional authority to have a real.
Please.
So let them make out their case.
Please.
also.
In fact, my lords, jurisdictional aspect also is there, because for an order to be revised under 263, the order should be both erroneous and prejudicial. If the single judge's order of this honorable court was already there at that point of time, how could the order of the assessing officer said to have been erroneous?
Malaj, that there is no reference to that order, Malaj.
Anyhow, that you will see.
Malaj may kindly
Now,
consider.
if it
Malaj,
is
let-
going to go back, then even on merits, obviously they can be given an opportunity to. The the petitioner has sought for setting aside the order at annexure E, whereby the revisional authority in exercise of the power under section 263 of the Income Tax Act has set aside the order of
The assessing authority, my lords.
the assessing authority insofar as the exemption extended by way of exemption for compensation paid has been set aside. Now, counsel for the petitioner submits that the order passed by the revisional authority is in violation of principles of natural justice insofar as notice was issued on 28/3/2023 to appear on by 12/4/2024 at 11 AM and take stand insofar as the proceedings of limited scrutiny assessment. While without waiting for 12/4/2023 on 29/3/2023 itself, the revision petition has been allowed.
The revisional order was passed,
The revisional,
or it's a
the
suo motu
revision,
revision.
revision, the suo motu revision was allowed. Full stop. Taking note of the admitted facts, once notice was given, extending time till 12/4, question of closing the revision proceedings on 29/3/2023 would be in violation of the time prescribed in the notice at annexure D, and accordingly is an order passed in violation of principles of natural justice, prejudicing the right of the petitioner to have put forth their case before the revisional authority in light of benefit of exemption having been extended to the petitioner in the assessment proceedings. All full stop. Insofar as the merits of the matter, needless to state, though contentions have been advanced on both sides, that's a matter that requires reconsideration, as once the petitioner is permitted to put forth their case, the authority may be in a better position to appreciate and arrive at a fresh conclusion in accordance with law. Accordingly, matters disposed of, the order at annexure
H.
H,
E and H.
E and H.
E and
H.
E and H.
H is
set as-
consequential, my lords.
E and H are set aside, matters remitted back to the revisional authority for fresh consideration in accordance with law. All contentions of both sides are kept open.
Lords may kindly note my reliance on the decision of this honorable court. I've just handed over a copy.
Which they can place.
I've said, anyhow, I've
Not
said,
disputing, my lords,
Ah.
this is settled.
anyhow, I've said both sides, that
Please.
both of you have advanced. Let us see.
They can rely, my lords.
It's only on that, rest remains open.
Obliged.
ಅದರಲ್ಲಿ Dilip accepts notice ಅಂತ. Yes,
This is a petition for assessment year 15-16. It is listed for the short point of disposal on notice being less than 7 days. Annexure A, page 43, if you honors were to see. Notice is dated 23rd March. Returnable by 29 March 22.
the petitioner. ಇದರಲ್ಲಿ similar order, but anyhow I'll explain. ನಮ್ದು ನಿನ್ನೆ ಮೊನ್ನೆ ಎಲ್ಲ ಮಾಡಿದ್ವಿ. The petitioner has called in question the validity of the notice under section 148 capital A small b at annexure A, as well as the order under 148 capital A small d at A1, notice under 148 at A2, order passed under 147 read with section 144, 144 capital B at annexure A3, penalty order under 271 within bracket 1 within bracket B at A4, and similar order at A5 and A6. It is the contention of learned counsel for the petitioner that the notice under section 148 capital A small b at annexure A is issued on 23/3/2022 with a direction for compliance by way of reply on 29/3/2022, which is in violation of the mandate of time of 7 days that is required to be afforded for making out reply to the notice under section 148A small b. Full stop. It is contended that in light of the inability of the petitioner to respond to such notice, in light of the short time made available, the petitioner has been prejudiced, and the consequential order under 148 capital A small d and other proceedings leading to the passing of assessment order are required to be set aside as being in violation of the statutory mandate under 148 capital A small b. Full stop. Section 148 capital A small b at clause 2, B.
149, 149, 1B.
B, my lord.
B.
B
B, my lord.
reads as follows. Full stop. Admittedly, the notice, the time afforded in the notice is less than the time of 7 days as required to be afforded. If that is so, the contention of prejudice being caused due to non-adherence to the time period under 148 capital A small b requires to be accepted. If the order under 148 capital A small d is to be set aside, accepting the argument of prejudice as made out and observed above, the consequential proceedings also are required to be set aside. Accordingly, the
Let's reply to 148 AB, my lord.
accordingly, the order at annexure
A1,
A1 is set.
148A also is required to be questioned.
Huh?
that's that.
Once the
Yeah.
notice is bad, that also is required to be quashed
my lords,
Now it's beyond time, is it?
beyond time.
my lords, that,
I have filed my return, I have given the working also, but they have not considered it.
Yes,
In
there
fact,
is-
I have filed my return.
my lords, from the date of notice, my lords may kindly appreciate, my lords, on 23rd March 2022, my lords. Their time is to reply is 29th March 2020. 7 days, my lords, is 7 days, it says, my lords. The Act section says 7 days. We've given 7 days. My lords, 148.
My friend is weak in maths, you know. 29 minus 23 is 6.
My lords,
It
the
cannot be
order
7.
20. My lords, 23rd also has to be taken. My lords, it was issued at 11 o'clock.
If,
My lords, and the
even if you
order,
take 23, ek, do, teen. it
You add
comes to
7, it
six-
should come to 30.
It comes to 6 days.
Yes, Your Honor.
No, but he's saying that let it be remanded to the stage of reply to 148 capital A.
Your Honor, if they have opportunity, let them do it again. But this notice is illegal, it cannot survive. Then they will come back and say tomorrow 5 days is sufficient. Mandate says not less than 7 days. They have deviated.
my lords, if they're,
No, but then why do you make such mistakes?
my lords, these are all initial,
Huh?
stage, my lords, at that point. Department also was not very familiar.
Anyhow, I'll keep it open. If in the writ appeal you get some relief, you can apply to.
Your Honor, I am eligible for the 50 lakh limit also. I am not pressing that because on the simple point it has to go. The sale consideration is 60 lakh, 10-year difference in purchase and sale, 2004 and 2014. If you index it, it will still fall below 50 lakhs. I don't want to go to the merits of the matter. That is why I am pressing saying it should go.
Next party order, my lords, they've never replied. My
No, no,
lords,
correct. Now,
so because
now-
of the limitation, my lords, we'll be it by limitation.
no,
we
that
cannot
is
issue
there,
this.
but here we could also take note of the merits of the matter.
Yes,
Now
Your
it
Honor.
is 60 lakhs.
Yes, Your Honor. I'll just point out.
Point out, let us,
Please, Your Honor.
for his satisfaction point.
Yes, Your Honor. If Your Honor were to take to my return of income,
Yes.
page 93. Bottom of the page, if you honest have 93.
Yes.
Sale consideration 60 lakhs. Less improvement. My net income is loss 5,568. The assessing officer says I should have filed the purchase document. Purchase document, I'll just point that out also. If you honest were to take to page 105. This
Yes.
was not available with the AO, but nevertheless, he has obtained the document, para 4. May I read, Your Honors?
Yes.
And whereas the said Anuradha Nagendra has sold the site scheduled property in favor of Ravi Kumar R, named the vendor herein, while sale deed dated 9/2/2004. The transaction is in 2014, sale transaction, 10 years. Even if I had bought it for 10 lakh, after indexation, if they reduce it, it will still fall below 50. They still cannot tax me. This is 15, 16. It would serve no purpose to keep it alive here.
Full stop. Again, but the last time. No, you made out the calculation.
No, my lords.
We did not file, no, the return I have filed the calculation. What I showed in the return of income, page 93, it is available before the AO. He makes full addition of 60 lakhs. I'm before Your Honors on the legal issue. I think the initiation is bad.
Anyhow, we'll refer to that.
Yes, Your Honors, please.
Order at annexure A1 is set aside. The notice at annexure A and the order at annexure A1 and the other proceedings at A2, A3 and A4, A5 and A6 are set aside. Full stop.
Please.
One paragraph added. Though learned counsel for the revenue would contend that the matter may be remitted to the stage of reply to the 148 capital A small b notice, as if the notice itself is set aside. The question of initiating fresh proceedings may be difficult in light of the permissibility to issue fresh proceedings at this point of time. Learned counsel for the petitioner submits that even on merits, as the requirement under section 148 capital A small d requires to record a finding that income accessible to tax
It's not,
has
it's under section 151.
151.
151. If it is, my lords,
148 ED is the order required to be passed.
50 lakhs and above, my lords, it's 10 years.
where is that in? That is in
Section 151.
That is only for sanction years.
no, but under
149
149
1B.
AD,
149 1B may be senior.
Please,
that-
149, my lord.
49 1B.
1B.
Yes, sir.
Yes.
So then it would be 3 years.
Please. Less than 50 lakh, 3 years. Beyond that, 10 years. But here my income would be less than 50 lakhs.
ಏನ್ ಬರ್ದಿದ್ದೀರಾ? ಅಲ್ಲ, as a requirement under section 149 1B is for income having escaped assessment. And if the income is less than 50 lakhs, the question of applicability of the extended time does not arise. And accordingly, the argument of learned counsel for the revenue is to be rejected, full stop. Next. In light of a perusal of the return filed by the petitioner at annexure B, isn't it?
Please, Your Honor. Annexure B1.
At annexure B1. And a prima facie perusal of the calculation made would reveal that the consideration taken is 60 lakhs, while calculation of capital gains would include deductions under section 48 as well. And if that is to be so, the value would fall below 50 lakhs. In light of the same, the question of reserving liberty as sought for by the revenue does not arise. And accordingly, the petition is disposed of. Now you get that matter adjudicated at some point.
Please.
Yes.
6, Ravishankar.
ಇದರಲ್ಲಿ ಏನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್? Office objection is waived. 5-1.
No, this matter has to be taken along with serial number 70. They are brothers and the transaction is a single transaction. I'll just point out here. Can be disposed of. Because it's supposed to be listed together, but it has come at number 770. Vilas Reddy, Your Honors. You know, this is a reopening. I am not on the merits of the reopening per se. The assessee has sold a property for 1 crore. Originally, they did not file the return of income. The assessment was reopened. The mail ID of the assessee belonged to the tax practitioner. The tax practitioner has filed the return. He has given the details. Income is available. The income tax has been netted against the TDS available and a refund has been sought. But no reply has been made. The assessing officer on the short point saying that the cost of purchase was not provided, made additions of the entire sale consideration. I'll just point out the income tax form first, Your Honors. Page 71, if I may take your honors. 77. The return was not verified. Page 71, annexure B. It's
This
saying
was-
invalid. On the right hand corner, if you see return date, middle of the page, 2522, below original. I have filed my return within 30 days. Then
where-
my refund is showing at 45,170.
No, no, where do you get the return date?
Return date, if you want to see 1819, about 4 lines below original. On the right hand side. 2522.
Yes.
If you honest were to come down to the same line, last item, 45,170 is my refund.
Yes.
Now I'll take your honors to page 78. This is the form which I filed. I have enclosed the full form. On the right hand top corner, 1 crore 3,75,000. Cost of purchase immediately below 97 lakhs 1,000 so and so. Income 6,73,000. Now I'll take your honors to the 148 AD form, page 43. The information from the department is available, bottom of the page, page 43, 4 crore 15 lakh. And then bottom of the page, below that, 1 crore 3,75,000. Now what has happened is, it was sold by 4 people as a composite amount. He initiated proceedings for making additions of 5 crores. Now I'll take your honors to page 50, 50. Bottom of the page, your honors, para 4 is there. Your honors have para 4. I will just read 3 lines above that. May I read, your honors? The SSE, it's on the right hand side. The SSE being non-responsive and no return of income filed for the year under consideration. The transactions with regard to sale of immovable property to the tune of 1 crore 3 lakhs is proposed to be added to the total income of the SSE under the head capital gains, a short-term capital gain. Since the SSE failed to respond to the notices issued and substantiate with supporting documents, transactions on sale of immovable properties for a total consideration of 1 crore 3 lakhs is proposed to be added as income in the hands of the SSE under the head capital gains, a short-term capital gains, and taxed accordingly. Now my return of income, I have given the working. The only lacuna on my side is I did not give the purchase deed. So I am before you honest, say he has taxed the entire amount and then levied penalty. And my email ID was not updated. That was one defect on my side. In the case of Abhilash Reddy, the email ID was there, but in Sandeep Reddy, the email ID was not there. Both are brothers. My only prayer before your honors is remit it back to the file of the assessing officer 148 AB. Since the return has become invalid, I will file the sale deed. If he is satisfied that the income is only 6 lakhs, let him drop it. Otherwise, I will file a return again in response to 148. That is a short point.
Why is the return invalid now? Because of the new order.
Originally, we had to post it. It was not posted in time.
Which one you're?
Return of income is required to be verified within 120 days. Either you have to sign it and send it by post, or you can get an Aadhaar OTP. The return was filed by the tax practitioner and he felt it complied. But thereafter, we realized that it has become an invalid return.
Yes.
Stage of 148 AB.
Yes. So this first one, we'll take one by one.
Please, your honors.
So this what you have referred is Abhilash Reddy.
Abhilash Reddy, yes, yes.
To the stage of 149?
148 AB.
AB.
Yes, your honors.
It's annexure A, page 40.
Next year, A may be retained. A1 to
Reply to
A5
this notice.
may be deleted.
The petitioner
6. Do one thing.
has called in question the validity of the notice under 148 capital A small b, comma, 148 capital A small d, order at annexure A1, 148 notice at A2, order under 147 read with section 144, comma 144 capital B at annexure A3, penalty order at annexure A4, as well as penalty order at annexure A5. It is the case of the petitioner that though 148 capital A small b notice was issued, the petitioner could not reply as the email ID of the tax practitioner at the relevant point of time was not updated.
No, the SSE's mail ID was not updated. It belonged to the tax.
The
practitioner.
email ID of the SSE was not updated. as it stood changed from the earlier one available with the department. Full stop. He submitted that consequently the order passed under 148 capital A small d and other proceedings pursuant thereto have culminated without participation of the petitioner. Full stop. It is pointed out that on merits as well, the assessing authority at annexure A3 has referred to returns not having been filed.
Please, Your Honors.
Where do you get that in the assessment? order?
Assessment order, in the assessment order, page 50, it is above para 4 units.
Yeah. In ಬರ್ದಿದ್ದೀರಾ? That no return has been filed. ತಾನೆ? At para 3.2. While petitioner in fact had filed the return as is evidenced at annexure
B and C, Your Honors.
E and C, though subsequently it was found out that the same was defective. Full stop. Even otherwise, it is stated that the details of computation of capital gains having been made known to the assessing officer by virtue of return, though not verified, same ought to have been taken note of in an appropriate manner. Next. Taking note of the submission made and having prima facie perused at the calculation sheet, case is made out for affording an opportunity to the petitioner to make out his reply to the 148 capital A small b notice and to permit the authorities to proceed therefrom. Full stop. Accordingly, the order at annexure
A1.
A1
To A5.
to A1 and the proceedings at A2 to A5 are set aside. Matters remitted to the stage of reply to 148 capital A small b. All contentions on merits are kept open. Accordingly, petition is disposed of. Now this one,
Please, Your Honors. I'll just point out the return of income, page 71, Your Honors.
here also same is it?
Same transaction, brother of the assessee, and 4 people have sold the property, he is one of the one.
So it can be, no, here also is observed, no return is filed.
Yes, Your Honors.
Return is filed here.
Return is filed,
So
page 65.
identical order can be passed.
Please, please.
Identical,
Identical order,
no change.
no change.
Annexure numbers also,
Annexure is also same. Your Honors.
same order.
You know, in this, there is a small change, I'll just
It is.
saying. Penalty, there, it is a notice and not order. A4 and A5, here in this case will be a notice. In that, the order is passed. Here, the notice is issued.
Annexure,
A4 and A5,
ಇದರಲ್ಲಿ second matter ಮಾತ್ರ A4 and
It's-
A5
order, penalty notice,
penalty notice. ಅಷ್ಟು ಮಾತ್ರ change.
obliged.
7, Mahesh sir, open.
Part assessment order.
Yes.
Notice not sent to mobile not giving only 1 day's time. Thereafter, not Shokas notice was issued giving 7 days time. So the auditor not was by the time he opened the website, not last date was already over. Because of that, not ex parte order, best judgment assessment order was passed. Not in similar matters, not this honorable court quashed not the assessment order. Not Ignite, this appeal was filed, not I undertake to withdraw the appeal. At that time, Lord, in fact, my father was suffering from cancer, Lord. Similar circumstances, Lord. Where appeal was filed, I was allowed to withdraw the appeal, Lord. Assessment order was quashed and that was remitted back.
You want to check, verify something or?
Oh, yeah. I'm just seeing where is the notice issue? He wants a reminder back to the single party for a fresh order. Leave it in the court.
What are the dates? Just point out the dates and whether notice.
Lord, first notice was calling upon me to furnish particulars was sent on 24/11, giving only 1 day's time.
24,
29/11,
29,
and giving time to me, Lord, 30th of November.
2023.
29/11/22, mobile message was sent, Lord, calling upon me to submit the reply on 30th November 2022. Thereafter, Lord, show cause notice was issued on 10/2/23.
Show cause notice on
10/2/23. Giving, I have to submit reply by 17/2, Lord, that is 7 days time.
no, this then according to you will be 6 days if you leave 10.
Even that also, Lord, because auditor, Lord, was not able to see it, Lord. By the time he opened the website, Lord, last date was already over. And I have showed you, produced medical records, Lord, to show that, Lord, my father was suffering from cancer, Lord. I was attending him, Lord, by taking him to the hospitals.
You have the order.
Assessment order is not annexure B, not
No, this reference to that show cause notice and reply.
the best judgment order 24/11. Your Lordship,
Page
ink page 15, Lord. Para 2, Your Lordship, no return of income has been filed by the SSC till date. SSC has not acceded to the request to register his PAN on the e-filing portal. Notice under section 142(1) was issued on 24/11. Notice has been duly served on the SSC on 29/11. SSC was requested to furnish the following particulars. He was requested to furnish the above details on or before 30th/11. Notice was served to me on 29/11. 30th November was the date.
so
Till date.
there also 7 days.
Yes, Lord.
Okay, then let it go back. Let us.
Yes. Let them upload the order so that the appeal proceedings will be dropped immediately.
Yes. The petitioner has called in question the validity of the assessment order at annexure B dated 3/3/2023. Full stop. The contention of the petitioner is that during the relevant point of time, now the medical records pertains to
My father.
but in the order son of shows something else.
But before the assessing officer, it was not.
In the point of time, the petitioner's father was diagnosed with cancer, as is evidenced at annexure A. And accordingly, petitioner was unable to participate in the proceedings and put forth their stand. Full stop. it is further submitted that the perusal of the order at annexure B at para 2 would indicate that the notice under 142(1) was issued on 24/11/2022, though admittedly communicated only on 29/11/2022 with the compliance by way of reply on or before 30/11/2022. Full stop. Now, even for 142(1), the SOP 7 days.
That is principles of natural justice.
So that SOP says 7 days,
Speed doesn't come there.
not here. Full stop. It is submitted that if the notice was served on 29/11/2022, question of making out a reply by 30/11/2022 was clearly in violation of principles of natural justice, as sufficient time ought to have been afforded. Full stop. Next. Heard both sides. It is to be noticed that the date of notice under 142(1), as is made out from the order at annexure B, though is 24/11/2022, the observations made at para 2 of the impugned order would indicate that the notice was duly served on the SSC only on 29/11/2022. If that were to be so, seeking for a response by 30/11/2022 is clearly affording an insufficient time, and order passed thereupon would be plainly construed to be in violation of principles of natural justice. Taking note of the plea of medical ailment of the petitioner's father during the relevant period of time, it would be an appropriate case for setting aside the impugned proceedings and remit it back to the stage of reply to 142(1) notice. 142(1) notice. Accordingly, the order at annexure B is set aside, matters relegated to the stage as referred to above. All contentions are kept open. Accordingly, petition is disposed of. The memo undertaking to file appeal pending is taking note of.
Please.
And petitioner is undertaking that you would comply with such undertaking is noted.
Please, today itself I will do it.
Let them, within 1 month's time, let them file a reply.
The petitioner is to make out his reply to the notice under 142(1) within a period of 1 week for 1 month from date of receipt of certified copy of the order. Petitioner is also at liberty to upload the order in the petition on the portal. Yes.
8, Venkatesh Ji.
Appear for the petition.
Yes.
My lord, this I have called in question the constitutional wires of section 16(4). And in similar matters, my lords have been passing interim order staying the demand subject to payment of 10% of the tax. At page 104, similar order is already placed on record, my lord. And in this case, I had already filed an appeal, had paid the 10% pre-deposit at the stage of the appeal, and therefore again it would not arise.
Now, who appears for which of the respondents?
My lord, 1 and 2,
Just
it would
give
be
it to-
center,
Give it to him. Give it to him.
Jeevan. And 2 to 6 would be Mr. Hem Kumar. 1 and 2 I take.
Jeevan accepts notice for respondent 1 and 2. AG M. Kumar accepts notice for respondents 2 to 6. It's the case of the petitioner that the legal issue raised is identical to the issue pending consideration before this court in other matters as well, including in WP 21211 of 2023. Full stop. Interim order passed in WP 21211 of 2023 reads as follows. In light of the same, there would be an interim order of stay of
Annexure B.
Annexure B. Full stop. Insofar as deposit is concerned, it is submitted that 10% as is normally insisted has already been deposited before the first appellate authority.
Yes, ma'am.
In light of the same, question of insisting on further deposit does not arise. This is the matter along with WP 2 Adinadi, same.
Grateful.
9.
My lords, I appear for the petitioners in this case, my lords. Let's, in this case, my lords, we are challenging the notification issued under the central GST at Annexure A and the relevant notification at my lords.
Jivan. Here your name is shown.
9.
My lord, they have not served the copy on me, my lord, in this.
Copy.
Let's, we have already served it. We'll serve it today also, my lords. We have, although we served it, I mean, at the time of filing, my lords.
So I'll have it relisted on Tuesday.
Much obliged, my lords.
Relist the matter in same stage on Tuesday.
Highly obliged.
9th.
9, 10 urgent, serial number 10 and 11 urgent, 12, PB Harish, 12.
Yes, Deputy Commissioner of Commercial Taxes.
State authority.
12.
Third Council Hemkumar accepts notice for the respondents. Yes.
The challenge, your lordship, is the notice at page 57. Notice dated, your lordship, 30/5/2024. Your lords could kindly come to page 48, your lordship, of the writ petition. This is the bifurcation, para 64, your lordship, is the bifurcation of the demand. Essentially, your lordship, we are concerned with category E, exempt transaction treated as taxable. About 269 crores demand is created here. About 140 crores of tax, about 120 crores of interest, and some penalty, your lordship. Your lords could come to page 28, the same writ petition. Para 35, your lordship. This is the set of transactions, your lordship, which we claim are exempt from payment of GST. And which the authority says, your lordship, we are not entitled. The rest of it, your lordship, are on exports, etc. I don't want trouble, my lords, on that, your lordship. Your lords will come to para C, page 35. The petitioner used to manufacture novel biologics as well as biosimilar insulins and antibiotics. Petitioner, your lordship, is Biocon Limited. The petitioner transferred.
You are referring to
para 35, your lordship. Page 28, para 35, writ petition, your lordship. Heading C.
yes.
The petitioner, which is Biocon, your lordship, used to manufacture novel biologics as well as biosimilar insulins and antibodies. The petitioner transferred the business undertaking pertaining to the same on an ongoing basis, ongoing concern basis, to Messrs. Biocon Biologics Limited, via two business transfer agreements dated 17/1/2018 and 8/7/2019. This transfer of business was done on the basis of
lump sum valuation of all the assets and liabilities connected to the business that was to be transferred. In the petitioner's books of accounts, this income from the transfer of business was recorded as consideration received in cash and cash equivalents. Since these transactions are transfer of a business as a going concern, the petitioner had correctly classified the same as exempt under entry 2 of notification 12 of 2017, which exempts services by way of transfer of a going concern or an independent part thereof. An extract of the same is reproduced below. This is a notification, Your Lordship. Services by way of transfer of a going concern as a whole or an independent part thereof. Now, the audit proceedings took place, Your Lordship. We explained this entire transactions, placing on record the business transfer agreements. We explained, Your Lordship, that the consideration is a lump sum consideration. So that lump sum consideration, Your Lordship, will be for the goods in stock, the services to be rendered, the cost of the employees to be transferred, then the goodwill. Therefore, Your Lordship, this transaction typically has always been exempted from payment of service tax prior to GST and post GST, Your Lordship, under the GST. Because, Your Lordship, the
consideration of transfer is exempt.
Yes, Your Lordship. Because the 2-3 difficulties will happen, Your Lordship, if the tax has to be levied. Now, the goods, Your Lordship, will attract different rates of tax, the goods to be transferred. Then the services will at different rates of tax. Goodwill, whether it is to be taxed, will be an issue. Therefore, Your Lordship, the government has always said that if you're going to transfer a business concern as an ongoing concern, it will be exempt from tax. 2 reasons. The person who's going to purchase is going to run the business. And therefore, he will pay tax on whatever outward supply happens. The credit which I have, Your Lordship, the input tax credit also will get transferred. There is a procedure for it, Your Lordship, that also will get transferred. If this is to be taxed, I have to pay tax, he has to take credit and utilize it for payment of tax. So calculation of tax will be a problem. Calculation of value of the goods and services will be a problem. Therefore, they always exempted it, Your Lordship. Now, we gave all this information to the authorities. My Lords will see the 01A that was issued to us, page 272. The 01A, Lordship, is at page 272. My Lords will kindly note the dates, Your Lordship. 14/5/2024. At page 305, Your Lordship. Issue number 9. We are concerned with issue number 9. On verification of the books of accounts, it is observed that you have declared consideration received value of 767 crores as ascertained from note 32 and 39, that the consideration received in cash and cash equivalents as shown below, BFI and biologics, that is 2 different business transfer agreements. It is seen that no liability has been given, only portion of the asset for rupees 705 crores and 62.1 crores of your financial statements, and this revenue has not been offered for tax. Hence, the rate of 18% is leviable on the same with interest as below. On the right-hand side, Your Lordship, the table is set out. This is the total transfer that took place, and as all this, Your Lordship, non-current assets, current assets, non-current liabilities, all that, Your Lordship, was indicated. Then now total consideration received is 767 crores. Liability of 69 crores and 69 crores is calculated. Now to this 01A, we give a reply, Your Lordship. My Lords will see page 308. 307, Your Lordship, he reproduces the submissions we made during the audit. And 308, my Lords will see outcome down below, Your Lordship. The reply of the RTP, that is a registered tax, and the annexure submitted is verified. It is observed that the RTP has wrongly categorized itemized sale as going concern sale, slum sale. Then he goes on to, Your Lordship, what is slum sale? On the right-hand side, Your Lordship, his conclusions are there. Page 309 towards the end. According to the business transfer agreements, what is sold is relating to biosimilar human insulin and biosimilar monoclonal antibodies and the related manufacturing equipment staff, along with the contracts, technologies, permit, license, and approvals. It can be seen that out of the subgroup of biologics, wherein various biosimilars and novel biologics are manufactured, only few are sought to be transferred. The items what is sold is not an independent entity and is not a separate business vertical, and only certain assets have been transferred without liability. He refers to the notification. Then he says, Your Lordship, notification is applicable to a going concern as a whole or an independent thereof. In the given case, the sale of assets made is neither a whole concern which is sold nor an independent part which is sold. Thereafter, it draws a conclusion liable to pay tax, Your Lordship. I give a detailed reply to this. Page 324, reply dated 25/2024, Your Lordship. At page 330, Your Lordship. From page 331, Your Lordship, we refer to the earlier notification of 2012, thereafter subsequent notification. And at page 332, down below, Your Lordship, para C.17. Moreover, the company submits the following submissions made to the regulatory authorities as well as approvals obtained from SEZ regulators on the slum sale to the SEBI, Your Lordship, as well as to the SEZ authorities. Then we give a submission, Your Lordship, that the entire thing is to be considered as a slum sale. And we followed it up, Your Lordship, with another reply on 23/5/2024, which my lords will find at 338. At 347, Your Lordship, para 6, we produce, Your Lordship, G.1. In addition to our submissions made, we are hereby submitting the copy of the income tax return of income and assessment order issued by the authorities on conclusion of the proceedings as Annexure 17. We request you to consider that the transaction is already verified by the income tax authorities and from capital gains on slum sale as well. And thereafter, Your Lordship, they asked for some more details, which my lords will find at page 359. Mail dated 27th May, Your Lordship. My lords have it, Your Lordship, page 359. Kind attention, Shri Dr. Pramod Kumar. Pursuant to our discussions with regard to the observation number 9, please attach the following documents. During 2019, biologics and branded formulations have been transferred on a slum sale basis as a growing concern. Assets and liabilities transferred from undertaking as transferred manpower, assets and liabilities including machinery, contracts, debtors, creditors exclusively meant for the segments transferred. On the right-hand side, Your Lordship, we request your good self to refer to the segmental accounting and reporting for the financial years. Then para 3, Your Lordship, we also, please note that these particular segments have been a subject matter of the Karnataka High Court approval, wherein Biocon Biopharmaceuticals merged with Biocon Limited. These segments were sold from Biocon Limited to Biocon Biologics during 2019. We give all these details, Your Lordship. This is given on 27th of May. We get the show cause notice, Your Lordship, on 30th of May, page 57. He repeats the same what was there in the earlier show cause, Your Lordship, and comes to the conclusion at page 117, Your Lordship. He says only few products have been, page 117, the third paragraph, Your Lordship. According to the business transfer agreements, what is sold is relating to so-and-so and the related manufacturing equipments. It is seen that out of the subgroup of biologics, wherein so-and-so, only few are sought to be transferred. items what is sold is not an independent entity and is not a separate business vertical, and only certain assets have been transferred without liability. Therefore, he creates this demand. Your Lordship. 2, 3 submissions, Your Lordship. The purpose of this exemption notification, Your Lordship, is only to ensure that there is no difficulty created both for the assessee as well as for the department in arriving at the value as well as the tax liability. 2, the business, Your Lordship, is always transferred. The person purchasing it will run the business and therefore the outward liability will come. He will pay the tax, Your Lordship. That's why, Your Lordship, the notification has been there right from 2012. 1 year. 2, the interpretation of the authority, Your Lordship, that only few assets have been transferred, few liabilities have been transferred is covered by the notification itself. The notification says services by way of a transfer of a going concern as a whole or an independent part thereof. My Lords will see page 117 down below. Consciously, Your Lordship, these expressions have been used. Independent part thereof, Your Lordship, few products, liabilities, assets, employees relating to that division also can be transferred. That also will be exempted. So, Your Lordship, if this interpretation is accepted, then we are giving a skewed interpretation to the notification. 2. 3, now if the authority says, Your Lordship, that this is not going to be a transfer of business concern, he is going to demand tax. Then what he should do, Your Lordship, is he should be in a position to arrive at what are the goods, what are the services, what has to be eliminated from this, and thereafter he has to demand tax, appropriate tax. What he does, Your Lordship, he takes the total consideration, which I have viewed as a transfer of business concern, tax it as a financial services and demands tax, Your Lordship. This can never be a financial services. Because he could not do anything better, he seeks to demand tax, Your Lordship, as financial services. Completely beyond the provisions and without any basis in law, Your Lordship. We'll also kindly note only that place in the show cause. And after I have given, Your Lordship, every document possible, what I gave to SEBI, what I gave to the income tax authorities, what I gave to the SEZ authorities, income tax authorities have accepted to be a slum sale and given us the benefit. Page 138, Your Lordship.
Yes.
My Lords will see on the top. 3rd line. It is observed from the said classification of services that SAC 9971 covers financial services and related services, and SAC 99711 covers financial services. The impugned transaction being a financial service gets covered under SAC 997119. If he's saying not a transfer, Your Lordship, then he has to do his job. He has to identify what are the goods transferred, what are the services transferred. Is it a composite supply, individual supply, what are the services? You can't take the entire consideration and tax it as a supply of financial services.
Yes. No, correct. They're raising a legal contention or an independent part thereof, which is again not necessarily mixed question, because your authority has said, no, it should be as a going concern in its entirety. So if the question of the second part of the notification is to be interpreted, the legal interpretation, then it would be, let's see.
That I will press that later, Your Lordship, not now. There are some background to this entire thing. I don't want to get into that now, Your Lordship, but why this demand is raised, etc. That.
Senior counsel appearing on behalf of the petitioners submits that notification 12 of 2017 provides for an exemption of, within inverted comma, services by way of transfer of a going concern, comma, as a whole or an independent part thereof, full stop. It is submitted that what comes within the purview of the exemption is also an services by way of transfer of an independent part thereof, full stop. Next. However, it is pointed out that while issuing the show cause, the primary assertion made is that the items sought to be sold is not an independent entity and only certain assets have been transferred without liability. It is submitted that the exemption covers transfer of services, transfer of services, no, covers services by way of transfer as an independent part thereof of the entity. And such part of the notification, though being clear, has not been taken note of by the authority. And if that were to be so, the notice could be construed to be one without jurisdiction, full stop. Even otherwise, it's submitted that the entirety of the consideration of transfer has been taken note without any bifurcation of the service component. And accordingly, matter requires to be interfered at this stage itself. Full stop. Counsel for the revenue submits that the matter is one at the show cause notice stage and petitioner may be permitted to participate in the proceedings. Next. However, taking note of the contention raised as noticed above, it's a matter that requires consideration even though it's at the stage of show cause notice. Accordingly, there would be stay of the notice at
Annexure A,
Annexure
Annexure A.
A till the next date. Full stop. The respondents are at liberty upon completing their instruction to seek for modification of the interim order as order is passed on the first date of consideration itself.
13. Chandrasekhar B.
The case of 148 AD order, 148 notice
Income
issued by
tax,
the jurisdiction assessing officer.
just one, income tax,
Sanmati or the Dilip. Similar matter, Sanmati has been representing.
Commissioner 4.
DCIT is a PCIT 2 range 2.
Sanmati. Is there, not there?
It is not there. Said he'll appear on VC.
I am told he said that he is appearing on VC. I don't know.
Let him accept, I'll have it on Tuesday.
My lord.
The same stage we'll have it on Tuesday.
Yes, ma'am.
You serve him a copy, we'll consider it.
Interim order can be considered, my lord. Similar matters, plenty of them are there.
What is
my
the
lord.
point?
The 148 AD notice and 148 notice issued by the jurisdiction assessing officer and orders passed, which cannot be done. It has to be entirely faceless, right from word go. Several such orders have been stayed by this honorable court, and by your lordship itself, I will cite a couple of decisions of your lordship, even interim stay.
No, then that issue, you get it settled.
Lords, in this budget, my lords, we are expecting some amendment. Lords, till this.
Some clarity.
Please.
In fact, the different high courts division benches have already held in favor of the assis.
No, it's a checkmate argument. That's why he's wondering what to do. So let's see then, in light of the contention.
Even today, my lords, it's done by the jurisdictional assessing officer. My lords, if their contention is accepted, my lords, there's no one case also, my lords, don't.
Correct. All
Everything goes, my lords.
In light of the contention of the petitioner that the proceedings of reassessment not be initiated through proceedings under 148 notice by the jurisdiction assessing officer, but ought to have been done by following the procedure for faceless assessment as envisaged under 151.
Yes, my lord.
And noticing that in accordingly, in light of such contention raised, matter requires consideration and there would be stay of
Annexes A1 to A5, my.
annexure A1 to A5.
Yes, my.
Tushal may be directed to take it. Tushal.
Learned Counsel
Tushal
Sri Sushant Tiwari is directed to accept notice for the respondent.
Please.
I undertake to serve copies, sir.
Yes.
14.
May I give the writ petition citation so that for clubbing purposes, it may be easy, my lord.
Let us see.
14, Ajay.
But you make a list from your department of all matters.
Yes.
So if at all on someday something, then the whole thing goes. You just make it. So when approximately when that's going to be done?
22nd.
No. When is the
Budget, my lords, it's on 22nd, my lords.
22nd?
Please, my second.
Anyhow, at your end, department, you make one consolidated list.
Please.
If there is, if the whole thing has to go, then by a common order, we can dispose.
Please.
14, Ajay.
My lord, seniors appearing online.
My lord, I appear for the petitioner online, my lord.
Yes.
My lord, this is a writ petition which challenges.
Just 1 minute, just 1 minute. Commercial taxes, Deputy Commissioner of Commercial Taxes. Just use the mic.
Yes.
Yes.
My lord, this is a petition which challenges a show cause notice dated 30th of May 24 for the year 2019-20. 3 issues are raised here, my lord. For the previous years of 17-18 and 18-19, identical issues were raised and a writ petition was filed and your lordships were pleased to stay the show cause notice. My lord, that order is at page, annexure H, page 175. Identical, my lord, for the same party. And my lord,
What was the point raised?
my lord, there are 3 points raised. My lord, may I just point out 2 other subsequent developments which are important. Of the 3 points raised, my lord, one is in relation to ESOPs which are granted by a foreign company to the employees of the petitioner company. They say that the foreign company is rendering a service to the Indian company, and therefore the value of the securities that my lord charges, they say that it's a supply of services. That, my lord, has been recently clarified by a circular of 26th June 24, very recent, my lord, and it's totally in favor of the SSC to say that there is no service involved. That's one. Second, my lord, they allege that there is an import of services by us from Flipkart, Israel. My lord, we have paid the full tax. Identical issues in 18-19, they themselves have dropped it, my lord. I've put that on record. Third is again in relation to some holding services which the foreign holding company provides. Again, my lord, covered by a circular, and for 18-19, they have themselves at the show cause notice stage itself dropped it. My lord, they gave us a pre-show cause intimation. We responded to that, citing the circular. They said when they issued the show cause, they themselves didn't take it up. They've dropped it. So
Just
all 3.
Just show us this 26/6/24.
Yes, my lord. This is a separate, my lord. My lord, my friend will pass it on to your lordships. This circular, my lord, if your lordship sees on the ESOP.
Yes.
Yes, my lord. If there's a detailed circular, my lord, where they talk about ESOPs being granted by companies, then, my lord, if your lordship sees para 2.2, doubts are being raised regarding taxability of a such transaction and under GST, whether such transfer of shares, securities by foreign holding company directly to the employees of the Indian subsidiary company and subsequent reimbursement of the cost of such shares or securities by the Indian subsidiary company to the foreign holding company can be considered as import of financial services. Identical issue, my lord. Then, my lord, they go into the whole issue. And my lord, finally, if your lordship sees para 4.6, the conclusion, accordingly, it is clarified that no supply of service appears to be taking place between the foreign holding company and the domestic subsidiary company, where the foreign holding company issues the ESOP to the employees of the domestic subsidiary company, and the domestic subsidiary company reimburses the cost of such securities shares to the foreign holding company on a cost-to-cost basis. However, in cases where an additional amount over and above the cost of securities is charged by the foreign holding company from the domestic subsidiary company by whatever name called, GST would be leviable. But we are not charging. This is our case is only on a cost-to-cost basis. So it's covered by the first part of this paragraph. And my lord, they themselves, so the majority of the demand is on this, my lord. It's out of the total of 182 crores, 175 crores is on this. And then, my lord, a small demand of 133 is on Israel. Full tax stands already paid. In view of that, my lord, in 1819, they have themselves, my lord, dropped the demand of penalty and interest. And the third one also, my lord, holding services, there is already an existing circular which said that there is no supply of service in such situations. That is, my lord, already part of the petition. Well, that circular is at annexure X, page 265. Well, in the table, the first point, whether the activity of holding shares by a holding company and the subsidiary company will be treated as a supply of service or not, and whether the same will be attracted to GST. Then, my lord, in the second para, first they note the provisions of the SC securities law, my lord, and then say this implies that the securities held by the holding company and the subsidiary company are neither goods nor services, or the purchase or sale of shares or securities in itself is neither a supply of goods nor a supply of services. For a transaction activity to be treated as supply of services, there must be a supply as defined under Section 7 of the CGST Act. It cannot be said that a service is being provided by the holding company to the subsidiary company solely on the basis that there is an entry SAC 997171 in the scheme of classification of services mentioning services provided by holding companies, that is holding security so and so, unless there is a supply of services by the holding company to the subsidiary company in accordance with Section 7 of the Act. Therefore, the activity of holding shares of subsidiary company by the holding company per se cannot be treated as a supply of services by holding company to said subsidiary company and cannot be taxed to GST.
I accept notice. In fact, my lord, the show cause notice is issued much prior to this circular. This is the latest circular after the 53rd council meeting, my lords. My lords may have it after 2 weeks, my lords. I'll see whether they can redo it in terms of the circular that is issued. To that extent, I'll make my submission probably on 16th, my lords.
What is the interim prayer you're seeking?
Lord, I'm seeking a stay of further proceedings, my lord, of this circular, like in the previous matter for the previous years.
Joint Senior Counsel appearing for the petitioners submits that as major portion of demands are to be raised in the show cause notice is covered by the clarificatory circular of 26 June 2024. It's further submitted that insofar as the same SSC for the previous year as regards other points raised in the show cause notice, matter is before this court. In writ petitions filed, interim orders are passed. Taking note of such contention raised, there will be an interim order of stay of further proceedings pursuant to annexure A till the next date. AGA M. Kumar accepts notice for the respondents. The respondents are at liberty to seek for modification of the interim prayer upon completion of instructions. This is the matter on
10th, my lords.
On 10th.
I'm sorry, my lord. 16th.
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 Orders list.
orders. So only to the limited submission of whether it can be done in view of the circular that is issued after issuance of the show cause notice. That's if that can be done, my lords, matter can go back there itself. Otherwise, it has to be agitated here.
In the orders list. Yes.
All right, deeply obliged.
Serial number 15, Tanmay.
May please, my lords. My lords, there are three petitions. My lords, all three are actually covered by my lord's order for the earlier year. These are petitions for assessment year 23, 24, 21, 22, and 22, 23. My lord, this my lord will recollect. Last week I had come. My lord, the question was I was collecting tax at source on a central basis in Bangalore, and an Uttarakhand officer had sought to exercise jurisdiction over me in respect of sales made in the state of Uttarakhand, and said that asked me to show cause as to why I have failed to collect tax at source on
Yes,
those
yes,
payments.
Yes, yes. Learned Counsel, Shri Arvind Chavan accepts notice for the respondents. Learned Senior Counsel appearing for the petitioner submits that as regards the case of the same SSC in WP 16686 of 2024, this court, after considering an identical question, had passed an interim order, and on the basis of parity, in light of the identical issue raised in the present petition, interim order may be passed on same terms. Full stop. Interim order passed in WP 16686 of 2024 reads as hereunder. Next, in light of the same, subject to further consideration, there would be an interim order of stay of annexures.
My lords, in writ petition 1706 is annexure H.
No, stay of annexure.
H for
H.
hotel.
Annexure.
My lords, in writ petition, there are different annexure, my lords, in the different petitions.
Yes, yes.
In 17037, it is H and K.
Just 1 minute.
Yes.
So annexure H, idralli. Next one. 16.
My lords, that is 17037. It is annexure H and K.
The same order, H and K.
17.
And 17179, it is H1, H2, and K.
H1, H2, and K.
K.
Yes. Serial number 15, 16, 17 to be called along with the WP 16686 of 2024.
Please. 18.
Obliged, my lord.
18, sir.
My lord, I've just been served with a copy. Or should I kindly have it next Tuesday, my lord? I'll make my submissions. Been served half an hour ago.
Let him have a look at it.
God, I gave a copy.
So he wants to have a look at it.
In fact, payment of current taxes I may be permitted.
In fact, I tried to get instructions. I've just been informed that the concerned RTO officer also been transferred. That's true, my lord. I'm not able to get instructions.
So we'll have it on Tuesday.
Tuesday.
At least till then I may permit to pay the current tax so that I could make use of the vehicle. 1/7. I will pay the tax. Let them accept it.
Tuesday.
They are not even accepting the current.
He's not been using the vehicle for almost 1 year now. 1 week, I don't see any issue happening.
Let us see on Tuesday. We'll pass.
Tuesday, my lord, please.
Third Counsel Chamant Naik seeks for a short accommodation. List the matter in the same stage on Tuesday.
Grateful.
Grateful. At least till then I may permit. Let them accept the tax, my lord. Nothing is going to happen. They will accept the tax so that I could make use of the vehicle. Otherwise, without payment of tax, if I remove the vehicle, then problem arises that they will seize the vehicle and unnecessary problem is
No,
there.
they're saying
Now, as on today, it is not there.
No, they're saying for 1 year you have not used. You wait till Tuesday and we'll.
Because 1/7, my lord, we have to pay within 15th. This month 15th is the last day to pay the tax. At least if I pay the tax today, I can make use of the vehicle for about 10 days.
Otherwise, we'll have it on Friday. Relist on Friday. Please, same state.
Okay.
19. Sunita?
Actually, the impugned order is Annexure B, page 23, where the order was passed merely on basis on
Assistant
the.
Commissioner of Central Taxes.
Jeevan sir will take notice. The order was passed merely based on the information derived from the income tax TDS of the assessee, your lordship, and the whole proceeding was done without serving the show cause notice upon me, your lordship. And they have intimated with the personal hearing also, where I have replied and I have asked for the service of the show cause notice, but it was never served to me.
No, now order is passed.
Order
is
in
passed,
original
your
has
lordship,
been passed.
without.
Now on merits,
Merits, I need to challenge your lordship because they have taken only the gross income of the service tax and the taxable tax payable to the income tax portal. Based on the income tax data itself, they have gone for the addition, your lordship. I mean, they have gone for this.
we
they have
can
passed
pass,
this.
we can pass over later in the afternoon in
Which one? My lord, your lordship may kindly, my lord, in page number 29, your lordship. If that is the only sole ground, my lord can pass over. But their ground is that, my lord, without issuing a show cause notice, they have adjudicated the matter. That may not be correct, my lord.
No, correct. But now, if under the
That
memo-
list, if it comes,
under-
my lord, then
we'll see.
we'll
They filed an affidavit saying in cases where orders are passed in the service tax matters, matter in that batch could be sent back to the stage of reply to show cause.
show cause notice.
That's the stand they've taken without going into the merits.
Merits.
So if you want to avail of that opportunity, go there and then make out your case on merits, then you can take benefit of it.
Lordship, here the show cause notice itself was not passed, though they claimed that it was issued, but it was never served upon me. Even the copy also was not shown to me. When they have given the intimation of
My
the
lord,
personal
that's why
hearing and each of the personal hearing I have attended and
you
asked for the show cause notice.
Then you find out.
Please,
Find out.
find out.
Next Wednesday, your lordship. Let annexure B be stayed, your lordship, till next Wednesday. Some protection may be given, your lordship.
Because adjudicating authority clearly says in his order that my lord, the show cause notice has been issued.
No,
And my lord, the show cause notice is received. White letter dated so and
Verified.
so,
it
something
was
like that.
only mentioned that the show
That's
cause
the-
notice was under the jurisdiction of the respondent number 2. Then the file allotted and transferred to respondent number 1 to pass the order. But the same proceeding was never.
That you verify.
Please,
Yes, your lordship.
And-
Some protection can be given, your lordship, for annexure B.
Respondents not to take any precipitative steps for recovery pursuant to annexure B till the next date. This is the matter in the orders list on. When do you want it?
Next Wednesday. or-
21.
Huh?
2 weeks, my lord, 2 weeks.
16th.
Please,
Much obliged.
16.
Number 20.
Lashu, here is a case, income tax matter, exemption, I think, Arvind sir will take notice.
Third council, Arvind Chavan accepts notice for the respondents. What is the case?
Lashu, here is the case against the application under section 119(2)B for rejection of the condonation of delay. What happened, your lordship? Here, this is for the first time, 2016-17, there's a mandatory compliance of filing 10B electronically, your lordship, e-filing of form 10B. But there is some 10B, form 10B. But there is a management discrepancy of the petitioner, your lordship. So there was a delay of 2 months due to the genuine hardship. He couldn't file that return and along with form 10B. So there is a delay of 2 months, your lordship, for which the petitioner availed that application under section 119(2)B, which was rejected, relying on the circular 7 of 2018, saying that there is no genuine hardship. The
My lord, now we have to find out whether the cause or the reason for the delay in non-filing of returns, whether it is genuine or not.
Yes,
That has to be examined.
the
I think
petitioner,
You furnish a copy. We'll have it next.
I'll furnish a copy. Some protection can be given you.
Now, what is the protection you are seeking?
Interim relief against the further proceeding of respond number two, Your Lordship, against the order of 119. So
No,
that they don't proceed with the, they don't proceed with the further.
Lord, there is no, against 119, it is petitioner who is aggrieved, they will come to this honorable court for setting aside.
Fresh adjudication must be done.
Either we have to do it, so I don't think so there is any interim protection needed, because if, unless they issue some recovery notice or
List the matter in the orders list on.
16th or 24th. 24th.
Recovery proceeding may be stayed till date, Your Lordship.
In case there is some problem, you have done it before, you move the matter, I'll consider. In the orders list.
Much appreciated.
Number 21, Tanmay Rajkumar.
This is a matter for the assessment year 2021. Challenges to the 148. That's the short point in this is the notice
21.
is issued. The proceedings are initiated on a non-existent entity. May I take my lords through the facts?
Madam, we have one file.
Mr. Raj, I think Mr. Tirumale should.
Exemption was.
And that's the proceedings are initiated on an entity by the name Allsite Software India Private Limited.
No, you want to go through?
Yes.
Or we can allow it. You point out, let us see, point out.
Very well. Malath, may kindly take the 148A-B notice. This is at Annexure C, page 76. Malath, the name of the entity is at the top, Allsite Software India Private Limited. And this is for the assessment year 2021. Malath, during the financial year 1920, with effect from 1/4/2019, Allsite Software India Private Limited merged into Informatica Business Solutions Private Limited. May I just take my lords through the audited financial statement?
You
the
want to
merged
check
financial
something
statement?
or if the facts are clear, we can allow, we can, I'll hear her. Otherwise.
I'm not clear about the facts, my lords. I'm just hearing what she's saying.
Okay.
I will just take my lords.
Or it may be taken up another day.
No, if the facts are clear, then we can allow it.
Yes.
So let her make out it.
Malath, may kindly see Annexure A. This is the merged financial statement that I had filed, that the petitioner Informatica Business Solutions had filed, taking into account the income of Allsite. And I might just take my lords to page number 61 of this audited financials, where the details of the merger have also come out. On page 61, note 34, amalgamation with Allsite Software India Private Limited. Informatica Business Solutions has filed an application bearing for sanction of scheme of amalgamation, and Informatica Business Solutions under section so and so. With the appointed date as 1st April 2019. The scheme was approved and confirmed by the regional director on so and so. Since the transfer company is a wholly owned subsidiary of the company, the purchase consideration for taking over the assets is nil, and the net assets and liabilities is taken over at rupees so and so. Well, as in response to the 148A-B notice, I filed my reply on 6th March, Annexure D, which is at page 79. My lords, we notice at the bottom of that page, in this regard, the company submits the following: merger of Allsite India with Informatica India. And on the next page, my lords, at the outset, the company wishes to inform that pursuant to scheme of amalgamation approved by the regional director, Allsite India merged with Informatica Business Solutions with effect from 1/4/2019. Pursuant to the above amalgamation, Allsite India has ceased to exist, and Informatica has taken over all assets, liabilities, registrations, responsibilities, and obligations of Allsite India with the appointed date of 1st April 2019. And the next paragraph, my lords, merged return of income filed by Informatica India. Given the amalgamation as stated above, since all the assets and liabilities of Allsite were amalgamated with Informatica India, Informatica India prepared merged financial statements, including the relevant transactions, operations, assets, and liabilities of Allsite India. Further, on 22nd January 2021, Informatica India filed its return for financial year 1920 based on the merged financial statements. Thereafter, my lords, the 148 AD order was passed. That is at Annexure E, page 103. My lords may notice that the name of the entity is at the top. It is in the name of All Site Software. And the order on the next page, my lords,
Now the reply you are filed for AB notice.
I filed my reply to the AB notice and I said that the entity has merged. Therefore, no proceedings can be initiated in the name of All Site. Despite that, the order is passed, and in the order, the officer says, basically, my lords, the proceedings were initiated because All Site Software had not filed its return of income. There is no question of All Site Software having to file its return of income because during the currency of the financial year itself, the entity merged into another entity, which is the petitioner, and the petitioner has filed its return of income, including the transactions of All Site, which I have brought to the notice of the assessing officer. May I just read the 148 AD order, my lords?
No, so then
Matter can go back, please. Or let him take appropriate action as per the law against the merged company.
That's straightly covered by Maruti Suzuki, my lords.
that is there. But yesterday Shamant Naik pointed out in the orders of amalgamation, there will be a clause. Now it is taken over, isn't it? Taken over by the new entity.
Yes, my lords.
So in the event, they find upon looking through the details, something is left out. We reserve a liberty, though however, if at all, it will be as regards the new entity.
My lords, my only submission, my lords, that liberty, anyway under the act, my lords, there is time limit to initiate proceedings on the new entity, provided there is sufficient information, my lords. This notice does not have any jurisdiction at all because starting from 148 AB, ending with the 148 notice under which the officer assumes jurisdiction, the notices have been issued in the name of a non-existent entity. Today, since the notice itself is without jurisdiction, given that it is in the name of a non-existent entity, my respectful submission is that, my lords, this matter cannot go back for continuation.
Correct. We can only observe that the subject matter of the 148 AB notice, if permissible, they could proceed against the new entity insofar as income of that old entity.
My lords, that my only submission is that liberty is available to the department under the act itself. My only difficulty is, my lords, if my lords reserves that liberty, my only apprehension is that that will be construed as a direction by this honorable court. My lords may kindly just observe that subject to law, the department may initiate such proceedings as may be prescribed.
So we'll dispose it of.
No, I'm in 144 AD order, he speaks of some GST turnovers and 3B and the GSTR1 turnovers and all. I'm not sure what is the turnover. So the amount is 32 lakh 20,000.
Now, if the time limit is still there,
yes.
So then you take action upon looking into it. If required, you see. Otherwise, you can examine.
We can dispose it, asking him to re-examine the matter in the light of the reply which has all been filed.
Correct. Now, what they're saying is everything stands transferred to the new entity, according to them. And they have also filed the return showing the income of the old one with the new one. So if you find something, then you
once again issue again the.
That's all.
My lord,
Otherwise, leave it because according to them, it's covered. They examine it at your end.
My lords, my only additional submission is the petition, which is Informatica business, was also assessed for this assessment year.
No, that's what she said. So that you examine. So that you apply your mind. The petitioners has called in question the validity of the order at annexure E under 148 capital A small d, as well as the notice under 148 at annexure F and the notice at annexure C, G, full stop. It is a case made out by learned counsel, so and so appearing on behalf of the petitioners, that the notice under 148 capital A, B has been issued annexure C is at page.
Whereas the 148 AB notice is at page 76.
Is issued in the name of All Site Software India Private Limited. by notice dated 28/2/2024 relating to the assessment year 2020-21, while the said entity has ceased to exist by virtue of the order of amalgamation at annexure.
My lords, in my reply at annexure D, I have annexed the order at page 82, my lords.
Then can continue the amalgamation order noting 11. By virtue of the order of confirmation of order of scheme of amalgamation
Dated 28
dated
October 2019.
2/8/2000 dated
My lords, the confirmation has come from the Ministry of Corporate Affairs on 28 October 2019.
dated 28/10/2019, showing the effective appointed date from which the scheme would be effective as 1/4/2019. Full stop. Accordingly, relying on the order of the apex court in the case of Dash versus Suzuki, it is submitted that notice to a non-existing entity is not legally tenable. Full stop. It is noticed that the notice under 148 AB is issued on 28/2/2024 with respect to the assessment year 2020-21. Full stop. The scheme of amalgamation has fixed the appointed date as 1/4/2019, and accordingly, after such date, the entity to which notice is issued is deemed not to be in existence. Full stop. If that were to be so, issuance of notice to Messrs. Allside Software India Private Limited requires to be set aside on such sole ground of entity not being in existence on the relevant date of issuance of notice. Full stop. Next. Court has also taken note of the submission made on behalf of the petitioner that by virtue of the scheme of amalgamation and there would be a transfer of liability, and even otherwise, returns have been filed as regards the new entity, taking note of the income of Messrs. Allside Software India Private Limited as well, and accordingly, there is no prejudice caused. Full stop.
May I just add, there is an assessment order also passed, and I have placed that assessment order at annexure B.
It's further submitted that as regards such income of Allside so and so, return filed in the name of the petitioner has also been a subject matter of consideration, as is evidenced by the return at annexure.
Evidence by the assessment order at annexure B,
Annexure B.
page number 64.
Assessment order.
Assessment order at annexure B. Full stop. Accordingly, the notices under 148 AB at annexures
There is a limitation in that 2020.
at annexures CG are set aside, and consequently notice at annexure F as well as the order at annexure E are set aside. Full stop. Needless to state, no, full stop. Next. The authorities may examine contention raised on merits as well, that the income of Messrs. Allside so and so has been subsequently declared in the return of income filed in the name of the petitioner after approval of the scheme of amalgamation, and assessment orders have already been passed. Full stop. If that were to be so, prima facie, question of initiating further proceedings does not arise. Full stop. However, liberty is reserved to the department as to take necessary action as is permissible in law if circumstances are so made out as regards the subject matter of notices under 148A(b) as is permissible in law.
May I just submit one point, my lords? My lords have directed the officers to examine the contention. My only submission is this, my lords. Under the under the reassessment provisions today, there are two different time limits available. One is within 3 years and one is after 3 years. Today, the proceedings are initiated in the name of the non-existent entity within 3 years. My lords, 3 years today has expired from end of the assessment year, and if proceedings were now to be initiated, they will have to satisfy the additional threshold under the under subsection 149(1)(b), my lords. My lords, if that is not satisfied, there's no question of further examination, my lords.
No, that's why it says as per law.
Very good.
Yes.
22.
There is.
Yes.
There's a writ petition challenging 148 proceedings for 1718. My lords, kindly take the 148.
Yes, income tax. Income tax.
In 22. My lords, kindly take the 148A(b) notice, Annexure B, page 25. My lords have it. Kindly see this assessment year 1718. The notice is for assessment year 1718. And kindly see the information that they have at page 26. My lords have that annexure. The assessment order for 1718 under section 143(3) was passed on so and so, accepting the income declared in the return of income by the SC. On verification of records, the revenue audit party has raised the following objections. The information that they have is this second para. The SSC had brought back so and so number of equity shares at a price of rupees so and so, each totaling rupees so and so during the year 2016-17 relevant to assessment year 1718. However, no additional income tax was levied on the SSC as per the provisions of 115 QA of the Act, which implies to tax on distributed income to shareholders. So basically the allegation or the information that they have is that the petitioner bought back certain shares at a so and so at whatever price, and additional tax under 115 QA has not been paid.
So that is for that year you're saying, 1718.
That's their information. Now to this I respond, if my lords kindly see my reply, page 29. Lords have that? Para A, the company submits the following. As on 1st April 2016, the company had so and so paid up equity shares which were held by specialist so and so. During FY 16-17, the company has neither issued any new equity shares nor bought back any equity shares. As on 31st March, the company had the same number of equity shares as paid up shares. The company submits the following documents: relevant extracts of share capital as per the audited financials, and a copy of AFS after the table, and a copy of annual return filed by the company with the Ministry of Company Affairs. There is no change in my share pattern from the financial statements. Their allegation is it was in 16-17. Now, if my lords kindly turn to page 32, the last paragraph of the reply. Separately, as regards the details of transactions mentioned in your notice, buyback of so and so, the company submits that the said transactions pertain to FY 13-14 relevant to 14-15, on which additional income tax has already been paid by the company. Now, despite this reply, their information is clearly wrong. I have submitted details showing, despite this reply, issues a 148. Now, what's the entire reason, my lord, to make amendment and for all these provisions and do the inquiries to see whether there is any escape, whether their information is correct or not. I am giving evidence to show that their information is wrong. So this is a fit case that they should have dropped the proceedings, apart from the fact that this is all information available in my assessment records. Now, under the old provision, they could have, if at all, reopened within 4 years. So proviso to 149 still protects me. They could not have reopened after 6 years. This 17-18, the notice is now issued end of March 24. So on both grounds, on merits and limitation, the notice has to go.
Yes.
I'll get instructions, Manoj. But Sushal may be directed to take it.
Then Council Shri Shal Tiwari accepts, directed to accept notice for the respondents. Is the matter in the orders list next week? 10th.
Stay of annexure E till then.
In the-
Annexure E is the 148.
In the entry regnum, taking note of the contention that the reply made out to the 148A notice prima facie would indicate that the proceedings are time barred. There would be an interim order of stay of yes till the next date.
Great.
23, Manoj, yes, sir.
No, many of this, Dilip must sit in their office and you sit as one authority, half the writs won't come. Now forget about merits. We are not hearing any matters on merits. We're sitting only on these. Many of the matters may have to just
The purpose of inquiry.
Because of time barring, Manoj, sometimes officers also will be left with no choice just to pass orders, also without considering. this.
No, in a
Because
case
of
like
time
this, my
barring-
lord, the entire purpose of 148A, B, A, D is to do a preliminary inquiry. If that is not done and 148 notices are issued mechanically, despite saying that there is no escapement, this is a clear case where the buyback took place in 13-14 and offered to additional income. They could have verified and dropped the proceedings. That's all they had to do. Mechanically issue 148 notices.
And every time 3-4 matters come on non-existing come, that position of law is settled. Now most of the amalgamation orders, that income liability will stand transferred. So if the transferred entity has filed, then you can check it. That will be available. If it is not filed, then what happens is only that there will be some doubt. So that also, most of it can be closed there only.
Please.
The petitioner,
Yes.
23.
the petitioner is a proprietorship concern carrying on the business of poultry farming. Well, it's for the period of July 2017 to March 2018.
Just
As-
1 minute, just 1 minute. Yes, who appears? Learned Counsel. Him Kumar, AG accepts notice for respondent 2 and 3. 1. Learned Counsel G1 accepts notice for the first respondent. Yes.
Well, in 2022, my assessment was audited under section 65, and I was on 2 grounds, my lords, at page 40. I was made liable to pay tax for a sum of rupees 5 crore 53 lakh 91,000 on the ground of wrong claim of ITC and non-payment of tax under section 9 subclause 4. Lord, subsequent to the receipt of the said audit report in the year 2022, I have furnished a detailed report. And after a lapse of 1 year, my lords, they have caused a show cause notice for a sum of rupees 7 lakhs. My lords, the said show cause notice was not served to my mail. Though initially, my lords, I was assessed for 5 crore. I have furnished the entire details, documents. My lords, after a lapse of 1 year, they have show caused a notice of 7 lakhs. With imposing a interest at the rate 8 lakh rupees at 120% interest. The said show cause notice was not served to me, my lords, through mail. And there's an order passed, Annexure A. At page 27, my lords, page 28, the RTP was also provided with an opportunity of personal hearing. A third para, my lords, further it is apprised that the above liabilities to be discharged in cash and reasonable time without prescribed. The RTP has not filed any reply till date. It's an ex parte order, my lord. The liability, my lords, is now I have claimed certain benefits under section 9 clause 4, which is an exempted.
But you did not participate in any of the proceedings.
My lords, initially when an order, I have not, subsequent to the show cause notice, my lords, I have not participated since I was not communicated with the show cause notice. A proper service was not.
Yes. Correct. Then you verify.
My lords, I have even not. My lords, it is a case under.
Anyhow, find out.
My lords, initially in 2022, my lords, I was made liable under section 9 clause 4 for a sum of rupees 2 crore 76 lakhs.
Let us see.
I have furnished the entire details.
Let us
But-
see.
No, my lords, initially the show cause notice was not served duly, my lords. If the
Let
show
us
cause
see.
notice was served upon me.
Let them verify. Let them.
Hello, sir.
Kumar appears for respondents 2 and 3. 1. And Council G1 accepts notice for the respondent.
My lords, one submission. If your lordship takes to page 50, my lords, this honorable court in a similar matter, my lords, I've remanded the case to the show cause notice stage.
Let us see. Let us see in case notice is served or not, they let them verify.
Because even if it is, my lords, served to the, even if it is remanded to the show cause stage, my lords, I can furnish the
We'll consider.
documents, my lords, to the satisfaction.
We'll consider it next week. This is the matter in the orders list on 10.
My lords, till then, my lords, since there's my account is, my lords, there's a notice to attach my account. Kindly, my lords. Only the recovery proceedings may be restrained till then.
Respondents not to take precipitative steps till the next date.
Great.
24, Sandeep.
Letter for the petitioners council. Serial numbers 24, 28, 30 and 31, my lords, all arise out of the same, not proceedings as such, my lords, they're all Wipro group entities. The issue is the same. But as your lordships was mentioning, these are also avoidable cases. It's clearly beyond the period of limitation. In fact, your lordships have passed stay order in similar cases where this is relating to the assessment of 2017-18. Now, the impugned order under 148 AD and the impugned notice under section 148 are beyond the 6-year period. 7th of May 2024. 31st March, that 6-year period have ended. I'll just take my lords through my lords has the first petition, serial number 24. Now, the issue as such, my lords, is with regard to certain firms, my lords, which had substantial shareholdings in the Wipro group of, in Wipro Limited and Wipro Enterprises Limited. Now, my lords, due to certain regulatory requirements of the RBI, the partnership firms that held those shares had to be reconstituted. Now, my lords, that is on the merits. I'm not really on the merits, even though I have a good case on merits. But what has happened in this case, my lords, is that already a scrutiny assessment order has been passed.
Just one. Yes. Deputy Commissioner of Income Tax.
Yes, I'm here.
Income.
On behalf of Sanmati, and
Yes.
some matters I think relate to me and some are Sanmati.
You appear. In some you appear.
Yes. Let him argue. Let him submit, I'll just find.
Yes.
So what has happened was, as I was saying, the underlying transactions are with regard to certain, where the firms, my lords, which held the shareholding were to be reconstituted. So I won't trouble my lords too much with the merits of that case, even though we have a good case on merits as well. But my lords, in the meantime, what had happened was we had filed our returns for the assessment of 2017-18. We revealed the fact that, completely disclosed the fact that the firms had to be reconstituted. No whisper then. When scrutiny assessment was taken up, 143.3 order was passed. Certain other issues were raised, my lords, nothing with regard to this issue. This happened as long back as, my lords, in 22nd of October 2019 is the 143.3 order. Now, my lords, in the meantime, your lordships may recollect, there was one, if I may use the word known troublemaker, Mr. Subramaniam, who repeatedly used to file cases. I think your lordships also may have heard. He filed certain representations before the income tax department. Of course, that went to Supreme Court. He filed his affidavit. But even then, notices were issued to me with regard to this very issue. Nothing came out of it. Now, my lords, on 31st of March 2024, a 148 AB notice is issued. So, calling upon me to show cause why all of these transactions should not be reopened. The impugned order, my lords, 148 AD order, is passed on 7th of May. My lords will find that in Annexure A1, page 65. And consequently, the impugned notice, Annexure A2 at page 115. Now, ex facie, my lords, these are beyond the limitation period. In fact, I think I'm told, my lords, your lordships have heard similar issues. For your lordship's convenience, we've also extracted the provisions, both post-amendment and pre-amendment. If my lords are to take page 288, these are the provisions as they exist as on today, post-amendment. At page 293 is section 149 as it reads today. My lords may kindly see, of course, no notice under section 148 shall be issued if 3 years have elapsed or not more than 10 years. Then, my lords may kindly see the proviso. Provided that no notice under section 148 shall be issued at any time in a case for the relevant assessment year beginning on or before 1st day of April 2021. Now, this is assessment year 2017-18. If a notice under section 148 or 153 or 153C could not have been issued at that time. Now, my lords, at that time would have relation to the time of issuance of notice. At that time, on account of being beyond the time limit specified under the provisions of clause B of section subsection 1 of this section, as the, and so as they stood immediately before the commencement of the Finance Act 2021. Now, the pre-amendment provisions are at page 281 onwards. So just to, before my lords goes there, just to break down this proviso, the way I read it, my lords, is that for any assessment year prior to the commencement of the 2021 Amendment Act, if no notice could be issued at the time of issuance of notice, in light of the provisions as they then read, then there's no question of the taking advantage of the extended period of limitation under the existing provisions. So the intention is very clear, my lords. It was basically to ensure that a limitation that would otherwise have been time barred could not be revived or resuscitated in light of the new provisions. Now, if my lords were to come back to page 281, now in addition to 149(1)(b), I can also take advantage of the proviso to section 147. If I may just read section 147 proviso, my lords, which is at page 281. Provided that, if my lords has it, provided that where an assessment under subsection 3 of section 140, subsection 3 of section 143, just pausing, my lords, in all of these cases, 143.3 orders have been passed, or this section has been made for the relevant assessment year. No action shall be taken under this section after the expiry of 4 years from the end of the relevant assessment year, unless income chargeable to tax is escaped assessment for such assessment year by reason of failure on the part of the assessee to make a return under section 139 or in response to a notice issued under subsection 1 of section 142 or section 148, or to disclose fully and truly all material facts necessary for his assessment for that assessment year. It's not the revenues case that I have not disclosed true and material facts. All of these, the reconstitution of the firms was admittedly disclosed, and in fact 143.3 orders were passed accepting my returns. There was no issue, except with regard to certain other issues.
So 4 years from?
4 years from the end of the relevant assessment year. So 2017-18, it ought to have ended on 31st March 2022.
31st of March?
2022. 4 years from the end of the relevant assessment year. Now, this is as per this proviso. Now, taking an even more lenient view. Now, I would respectfully submit the limitation expired in 2022 itself. Now, even assuming, my lords, this proviso does not apply. Kindly see page 285, my lords.
No. So it should be in terms of the...
Absolutely.
You read 149 proviso, it would refer back to the time available under the old one insofar as those before April 21.
Correct, absolutely. in light of the provisions as they then read. And as I was submitting, the intention was to ensure that you don't resuscitate an assessment that would otherwise have been time bound.
So in each of these same contentions.
All of them are the same, all of them dated the same. Interestingly, on the merits, but since your lordship asked, now there are retiring partners, incoming partners, and there's a firm. All of them have been brought to tax now on the same grounds. Now, even on merits, I mean, there was any even minute application of mine, either the tax liability would have been affixed on the incoming partner saying that capital assets have been brought in, or the outgoing partner, or on the firm itself. Now, this is very clearly just a shot in the dark saying, let's see which one sticks. But anyway, I won't go into merits because I understand, but it's beyond probably this honorable court's jurisdiction.
And the senior counsel appearing for the petitioners submits that the proceedings for reassessment sought to be initiated pursuant to a notice under 148AB issued is clearly hit by the time limit available under the previous provision.
Yes.
And if that were to be so, in terms of section 149, 1 proviso, as the matter relates to proceedings before 1st of April 21.
Yes, assessment year 2017-18.
Relates to an assessment year prior to 1st of April 21. The present notices are barred by time. Full stop. In light of the contention raised, matter requires consideration. Accordingly, there would be stay of
Annexure A1 and A2. A1 is the order under 148 AD and the notice under section 148 is annexure A2.
A1 and A2.
Only A1 and A2. Only A1 and A2.
A1 and A2.
Yes, sir.
Now, in all the matters,
All same.
same.
Absolutely the same. No difference in facts whatsoever.
Same order. Learned counsel, in the first matter, learned counsel Sanmati, first matter.
Yes, sir.
Accepts notice for respondent
Serial number 24.
2 to 6. And then Union of India,
I think they can only.
They can let him take it.
Manjunath, Union of India.
Madan Pillai.
Pramod accepts notice for the Union of India. Okay, second one.
28.
Now, what is this IA1 of 24
Dispensation.
is filed?
Dispensation
seeking
of certified copy of
dispensation
A1
of
and A2.
production of certified copies, which is allowed,
For you only I'm taking.
is allowed.
Women Sanmati, I told you.
28.
28, 30 and 31.
So 28 who appears?
24.
24, I think. 28 also, I think Sanmati.
28 he will take.
28
31 I will take.
28.
And there's 30 also in the middle.
28.
Sanmati and Mr. Sushil Tiwari.
First Union of India. Sushal Tiwari for 2 to 6. Same order.
Yes.
30.
30, I think again, Mr. Sanmati or Sushal.
I'll take it.
30. Same order. Sushal Tiwari accepts.
31 I will take.
31.
Oh, 2 to 8, I'm told. There are 8 respondents in serial number 30. There are 8 respondents, 2 additional respondents in serial number 30. So only thing your lordship's order may say notice for respondent numbers 2 to 8 instead of 2 to 6.
30 and 2 to 8, same identical order. 31.
31, I think Mr. Thirumalesh.
31 I will take.
And Council Thirumalesh.
2 to 6 only.
6, same identical order.
All 4 petitions could be linked together because they're all
matters to be called together. Serial number 24 to be called along with 28, 30, 31.
Grateful.
25. Tanmay Rajkumar.
This is also an order passed under section 148 AD and notice issued the 148 on a non-existent entity. But the facts are slightly different, my lords. And it's the
Who appears?
I am up here.
BCA. My lords, I see the notice at page 223. Annexure F.
If it requires some taking of instruction, we'll have it next week.
Well, it's the only issue is this, Malad. The name of the entity is Entity Data India Enterprise Application Services Private Limited. This entity, my lords, merged into another entity way back in the year 2013. So for the assessment year 2017-18, for which the proceedings are initiated, itself this entity was not in existence. It is not that it is not in existence today, my lords. In 2013, it merged into another entity. That entity was assessed for AY 17-18. Now that entity merged into the petitioner in in financial year 22, my lords. So today, neither is the entity on whom the notice issued existent. That entity ceased to exist as far back as in 2013. The entity into whom this entity merged was also assessed in 2017-18, and that entity also is not in existence today. Today, who is in existence is the petitioner, my lords, into whom the previous entity has merged. This is the slightly different fact pattern from the previous writ petition. Otherwise, my lords, the issue remains the same. All the receipts in the name of the entity on whom the proceedings are initiated were taken into account by the entity who was surviving. The entity is already assessed to tax also. Quite apart from this, my lords, while I'm canvassing my first ground as the notice being without jurisdiction because it is in the name of a non-existent entity, point is also, my lords, today the proceedings are barred by limitation. This is for assessment year 17-18. The proceedings are initiated after expiry of 3 years. Now, after expiry of 3 years, if the 10-year period has to be invoked, my lords, there are certain conditions which the department has to satisfy. Today, neither in the notice nor in the order have they pointed out as to which of the limbs of 149(1)(b, which deal with extended period of limitation, are
Have it next
satisfied.
week examined.
Yes, yes.
Land Council Tirumalesh accepts notice for the respondent. This is the matter in the orders list on
10.
10.
Till then, could the 148 notice be stayed, my lords?
Respondents till the next date proceedings pursuant to the notice at annexure
F, page 223.
are stayed.
26, Lakshmi.
Lordship, I appear for the petitioner. The issue in this matter is, Your Lordship, it's the assessment.
Just 1 minute. Commissioner of Central Excise and Central Tax.
I'll take note. Central tax, central.
Now you accept first respondent.
For the first.
Samant Naik for the first respondent. That comes Arvind Chavan for respondents 2 to 4. Yes.
Your Lordship, the issue is with respect to where the additions are made based on the ITR and the financial declarations of the petitioner, Your Lordship. This honorable court has adjudicated that matter in annexure G and G1, Your Lordship.
Annexure
G and G1. Your Lordship, in this matter, the petitioner is engaged in the business of construction of the individual residential houses, Your Lordship. And the same is been exempted.
Stay again. Pleading for.
You may point out one.
No, those proceedings are Concord Housing Corporation Private Limited.
Your Lordship.
Annexure G.
Yes, Your Lordship. Your Lordship, the issue is with respect to where the assessment proceedings have been carried out based on the ITR and the financial declarations, Your Lordship.
Now on merits.
Your Lordship, the petitioner, the show cause notice is issued.
Look, that's on the procedure.
Yes, Your Lordship.
Now I want to know on merits whether this is exempt, reverse charge mechanism, negative list.
Yes, Your Lordship. The petitioner is engaged in the business of construction of residential houses, individual residential houses, Your Lordship. Your Lordship, I may direct Your Lordship to page number 87.
You're directing me. Yes, page 80.
87. I may take you through.
This is exempt, is it?
Yes, Your Lordship.
Ah.
For the mega exemption, it's exempt.
Which item?
Serial number 14, Your Lordship. Page number 87.
Services by way of construction, erection, commissioning pertaining to which subclause?
14 clause B, Your Lordship.
14 clause
B.
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 single residential unit,
Yes, Your Lordship.
single residential.
Yes, Your Lordship.
Now assessment order is already passed.
Yes, Your Lordships. We have gone and appeal, Your Lordship, but however, due to, Your Lordship, I would like to make a submission that with respect to the petitioner is suffering from depression disorder, due to which he has not been able to represent before the authorities with respect to the show cause notice or attend any personal hearings. So pursuant to which the Annexure B has been issued, the order has been issued, and further on, we have appealed, but it's been rejected based on the due to delay. So I request Your Lordship to remand back the.
Appeal was not filed within time limit. It has filed beyond the time limit. Hence, it has been dismissed because Commissioner does not have power to go condone the delay.
Your Lordship, you may refer to Annexure D, Your Lordship, where we have produced the medical certificate of the petitioner. He is suffering from depression disorder.
This one.
He did
Annexure,
not make note of
annexure,
D, Your Lordship,
page.
page 63.
Depression.
So the petitioner has the tendency to elope and he's not at the
Now-
station most of the
Now,
time.
we can pass it over. Let us see. In those other batch at 2:30, wherever assessment order is passed, if they are claiming an exemption, let's see what.
Much of
What I would only submit is that, my lord, because here they have crossed one other stage, my lord. After order in original, they have gone to
Correct.
order in appeal and delay has not been condoned. It may be called after 2 weeks if after the passing of that 230 matters orders, my lord. Then whether it is applicable, we can apply it.
Otherwise, on merits, you get your
Lordship, it may be heard together.
instruction.
Please, 24th, it can be listed, my lord. I'll try to take page 6.
Your Lordship, the matter may be listed along with the connected matters, Your Lordship.
Let us see, let us see. Now here, because the appellate order has been rejected, but we'll consider it independently also.
It has to be considered independent.
We'll consider it independently also. In case, let's see what instructions they get, we may consider remanding it.
Much of
Learned counsel. Arvind Chavan accepts notice for respondents 2 to 4. Shamant Naik for R1.
One.
And is the matter in the orders list on
24.
24.
27.
much pleasure.
Copies, Behari. One again, Manigal. 2 sets of copies. Madam, one more thing. I have.
Please, my lords.
Which is your serial number.
This is a writ petition challenging the order under section 74 under the Karnataka GST Act.
Yes, who appears?
Bashar.
My lords, for the month of February and March 2020, for the month of February, the due date for filing of the GSTR 3B monthly return fell on March 20, and for the month of March, it fell on April 2020. Now, during this period starting March 15th, COVID lockdown was announced. Therefore, the GSTR 3B monthly return could not be filed within due date, and the due date was later extended. I filed my 3B monthly return for the month of February 2020 at page 45, my lords.
For the month of
February 2020. I filed my 3B monthly return for the month of February 2020 on 25th of July 2020. 25th of July 2020. I make a mistake in the monthly return. My outward supply, what I have to show, I show it at a very high inflated for a value that has no relevance at all. It was a mistake on my part. On both for February and March, I make the same mistake. On 25th of July, I however realized my mistake. But in the
procedure for GSTR 3B, there is no scope for revising the return. Upon realizing my monthly filing for GSTR 1, wherein I disclose my outward supplies, sales, I correct the return, which was filed on the 26th of July, very next date. On the very next day, I correct my mistake and the sales I have corrected. The monthly return for February 2020 is at page 45, my lords. I have shown my sales as 2 crore 64 lakhs 60,439. Lordship may see page 45. Outward taxable supplies 2 crore 64 lakhs 60,439. That's the outward supplies. This is Lordship may see little above on the first table 2D date of ARN. That's a reference number, my lords, 25th of July. That is the date of filing. Now, Lordship may see the monthly return that is filed for February 2020 for outward supplies GSTR 1 at page 35.
At page?
35. 35. It was filed the very next date. I immediately realized my mistake and I disclosed the correct figure. Page 35, my lords. Lordship may see ARN date 26th of July 2020. The very next date. My outward supplies is correctly shown at 32,70,738. Total invoice value. Total invoice value. This is the correct figure. And when I filed my annual return, my lord, similar mistake happened for the month of March as well, February and March. And when I filed my annual return on 24th of February 2021 at page 49, I disclosed my outward supplies correctly at annual value of 2.85 crores. Now, this was the position. I could not file my GSTR revised return. I could not do anything about it. Section 74 proceedings are initiated on this basis, stating that you have shown the sales at a higher value and you have you have utilized ITC more than what you ought to have utilized. And Section 74 order was passed at page 57, my lords. It is shown here that DRC 1A notice was issued to me, intimation, but that intimation was not received by me. However, show cause notice was issued to me, to which I appeared. But on account of not getting the right professional advice, I could not make any representation. I appeared before the officer personally. I sought for 15 days time, but I could not get any professional advice and no reply could be filed for the show cause notice. Lordship may come to page 60. So the sole issue being this difference, my lords. Apart from this, there is no other issue for this year. Page 60, conclusion. Incorporated the above. May I read, my lords? Incorporated the above, show cause notice issued under Section 24(1) of the KGST Act for the tax period 2019-20. Mr. Mohammed Bilal Ahmed, proprietor, is appeared on 15th of March 2023 and filed letter and sought 15 days time to file reply and documents. The taxable person has not filed reply to the show cause notice issued even after availing more than 15 days time. One more opportunity was provided to the taxable person to file reply by issuing endorsement dated 28th of April 2023. The taxable person has not filed the reply even after giving sufficient time. The taxable person is liable to pay tax interest penalty. Hence, the determination of tax, interest and penalty as under. And in this way, my lords, a heavy demand of 94 lakhs 80,489 under IGST, 25 lakh 84,511 under the CGST, and identical amount under SGST is determined on my name. I cannot go in appeal against for the setting aside of the order of the adjudication, sending it back to the officer for first consideration. I'll make all the suitable submissions, submit my bank statement, submit everything, because I've already filed the GSTR 1. And he has merely blindly gone on the face of the record of 3B allowed. He has not considered my monthly return. He has not considered my annual return. He has not even examined those aspects. And in the online portal also, no orders were uploaded. Page 72 is the online portal. Apart from the summary of the order, no other orders were uploaded. I of course take the responsibility of appearing once again before him dutifully and presenting all the records, my lords.
They have not participated. Once they appear, seek for time, which is granted, endorsement is issued, for which there is no response. And the order has been passed on 31/5/2023. More than a year since the order has been passed. They could have preferred an appeal against this order, which they have not done. They have satisfied knowledge. India, after recovery notice has been issued, DRC 30, share before this honorable court.
I only seek another opportunity, my lords. The recovery notice is at page 76, my lords.
All knowledge are not all part of the government. DRC 3, DRC 1, whatever is argued on merits, It's not there. It's only grounds that the canvas is that it's an expiry order. And they wanted an opportunity of being done. But now that ample opportunity has been granted.
If I may submit, my lords, this is not,
Allegations of the officers that he is not given them opportunity. They have not said why they have not participated in it.
my lords, the demand is unenforceable under the law, my lords, because the demand has arisen on account of wrong figure entered by me on GSTR 3B monthly return, which was corrected immediately the next day. A examination of 3B versus 1 was not made by the assessing officer. He ought to have examined that the figure has no relevance at all. And if I submit my bank statement now, it will be revealed.
In fact, pursuant to passing of this order also, they could have filed an application for rectification. If they were so aggrieved by all these observations. They don't file an appeal. They don't challenge the correctness of this order. After 1 year, when on 6/6/2024, recovery notices have been issued. It is only then they come up before this honorable court and these allegations against the officer that he is not granted them opportunity. After 1 year, when you have initiated recovery, my lords were just court to grant an interim order.
No, we'll have it next week. You get instructions.
Please.
Relist the matter, Land Council, M. Kumar accepts notice for the respondents. Relist the matter on, when do you want? The orders list on 10th.
Let them not take any further course of action, my
See,
lords.
on 10th, you have, now, see, M. Kumar's objection is that you waited for more than a year since
Yes,
the
sir.
order is passed. You wait, next week we'll see.
Please, my lords.
Then 29, Srihari, 29.
It should not be also, the bench is too soft, so now all the old matters you start filing.
My lords, but this is a case, this is not a case where any other alternative remedy was availed, my lords. I'm a person who has not been properly advised.
We'll consider next.
I bowed on to this court, my lords. I bowed on.
Yes.
29, Srihari.
My lords, serial number 29. This is a writ petition challenging the order of cancellation of registration. I'm purely on procedure of law here. Purely on procedure of law. A show cause notice was issued to me proposing cancellation of my registration on 2nd of February 2024. On 2nd of February 2024, a show cause notice is issued to me proposing cancellation of registration. It's at page 46, my lords. Page 46. Lordship may just have a look at the show cause notice and how it has been laid out. Show cause notice for cancellation of registration. May I read, my lords? Whereas, on the basis of information which has come to my notice, it appears that your registration is liable to be cancelled for the following reasons. And this is the reason, my lords. Section 29(2)(e), registration obtained by means of fraud, willful misstatement, and suppression of facts. That's it. Apart from this, nothing is laid out in the show cause notice. What are the details on the basis of which he proposes to show cause notice? And how am I to even show cause? On what basis, my lords? This is merely a head note of the section. This is what merely reading of the provision. He then says you are hereby directed to furnish a reply to the note to the notice within 7 working days from the date of service. Now, this notice is issued on 2nd of February 2024. And he says you are hereby directed to appear before the undersigned on 3rd of February, the very next date, morning 11 a.m. That's the show cause notice. And now the interesting part, my lords, I was subject matter of investigation under the GST. On 22nd of January, I was taken under judicial custody. When the no show cause notice was issued to me, I was under the judicial custody.
When this, on second.
Yes, my lords. Annexure C at page 25 is the arrest memo. I was under the judicial custody. They take me, they conduct investigation. They take me in judicial custody. Issue a show cause notice to me when I am in judicial custody pursuant to their own action.
Where is the reference to the date of arrest?
Date of arrest, my lords, is on 22nd of January 2024 at page 25.
Page?
Page 37, my lords, sorry.
My lord, it's at page 49.
Page 37, my lords. 37, my mistake. There is multiple page numbers here, I'm sorry.
On 22/1/24.
Yes, my lords, 22nd January 2024.
You were arrested.
I was arrested. I'm under pursuant to the GST proceedings. Show cause notice is issued to me on 2nd of February when I'm in judicial custody, calling me to appear before him personally the very next date, 11 a.m. I obviously could not appear.
Now you were released when?
I was released, my lord, on 29th of February 2024.
29th February.
29th of February, I got a bail from the Sessions Court 29(2). Now, continuing from the proceeding, my lords. So I was issued show cause notice on 2nd of February, asking me to appear on 3rd of February. On 16th of February 2024, at page 47, my lords.
No, no, only on this ground it has to go.
Yes, my lords.
I understand. After that, what they've done is, if your lordship sees page 61, he makes a representation, my lord, for revocation of cancellation of GST registration. So there he says he doesn't challenge the cancellation there. He wants the cancellation to be revoked. There again, my lord, we passed an order. He forgoes his opportunity, my lord, to challenge the very cancellation by, my lord, making this representation of this application at G1, page 61. To that, my lord, we have responded. He is in fact a bogus bill trader. And my lord, we had to close the account. Your lordship may have it on Tuesday. I'll not seek instructions. In fact, we'll have to secure that amount. Maybe the notices are, I would off record submit, my lord, maybe a little unfair that he's got a day's thing, but we'll have to secure the amount, my lord, in that account. So lordship may have it on Tuesday, my lord. I'll seek instructions, ask the department what they intend to do, and then thereafter, my lord, your lordship may set aside. In fact, if your lordships were to even keep the registration cancelled for now, and then, my lord, let them make another representation to say as to why their cancellation should be restored before the SI. We will consider that, my lord, within a time-bound period.
No, my lord, show cause notice.
Let this be treated as a show cause notice, my
correct,
lord.
yeah.
We'll keep that.
Right, but your show cause notice.
I understand, my lord.
Cryptic. You may
No,
have
I
to
understand, my lord. I
reserve
understand.
liberty to read.
I understand. Lordship may have it on Tuesday, my lord, for disposal.
Council Chaman Naik accepts notice for the respondent. List the matter. The orders list.
Great.
On.
Great.
Obliged, my lords.
30, 31, Arjun. 32.
83
Yes.
Yes.
My lords, another case of cross empowerment.
Assistant Commissioner of Commercial Taxes.
Lords, another case of cross empowerment under Section 6 of the CGST Act. The case,
Now, who's the jurisdiction is by whom and who's the competent authority according to you?
yes, my lords, the petitioner's case is that the proceedings are without jurisdiction because the state authorities have proceeded against them, whereas he comes under the center for administrative purposes. The lordships has already granted stay in many of the petitions. And this honorable court has granted stay in 2 of the petitioner's own case for earlier period. And I have, may I furnish a copy of the stay order granted by your lordship? And the same point.
Now, this order in 13652, identical contention.
Yes.
Identical.
Yes. The center has proceeded, whereas, I mean, the state has proceeded.
But notification is not.
It says the notification of the and which already came for notification. Madras High Court has said that the notification. That's your knowledge, that a petition that came.
The counsel for the petitioner submits that in the case of the same SSC in WP 13652.
No, my lords, SSC is different.
Yeah, in this court, wherein an identical issue has been raised, as raised in the present matter, has considered grant of interim prayer in WP 13652 of 2024. Interim order passed in WP 13652 of 2024 reads as follows. In light of the above, There would be stay of
Annexure C, my lords.
annexure C and further proceedings pursuant thereto. And Council M. Kumar accepts notice for the respondents. List the matter along with WP.
My lords, I'm furnishing a list. There are about a batch of 8 petitions.
WP numbers so and so. Now you just find out what is to be done in these.
Much obliged.
Respondents are at liberty to seek for modification of the interim prayer upon completing their instructions. Yes.
33, Srihari.
I think 33 to be taken up next Tuesday, my lords.
Relist the matter in same stage next Tuesday. Next.
34.
My lords, appearing for the petitioner, my lords. My lords, in this issue, the petitioner is challenging the form DRC 01, wherein the respondent number 2, that is a commercial tax officer, is proposing to demand GST on the issue of salaries paid to the expats seconded from the overseas group company. On the very same issue,
Stay in similar matters.
on the SSC's own case, my lords, for the previous period.
Right. Accepts notice for the
Sorry.
respondent. Yeah, it is submitted by counsel for the petitioner that as regards to the same SSC for a different period, wherein an identical issue has been raised. This court in WP 14689 of 2024 has passed interim order. The interim order passed in WP 14689 of 2024 reads as follows. In light of the above and taking note of the contention raised, there would be stay of
Annexure A, my lords.
stay of annexure A and proceedings pursuant thereto. List the matter along with WP 14689 of 2024.
Directed to serve copies.
Copies to be served.
Right, my
Council Shaman
Right.
35.
IA 1 of 24 is allowed and petitioner dispense with production of certified copy of annexure A.
Shankar is to appear in this matter, my lords. Can we have it on 10? I mean,
Relist the matter in the same stage on
10.
It's become infructuous, my lords.
Maybe.
Lords. Prayer, my lords, in the writ
You
petition.
know, my lordship may kindly see the prayer, my lord. The prayer has been answered. Right.
Quashing the order of detention. Detention, isn't it? Huh.
Prayer. My lord, interim order, my lord, came to be passed on 14th, on the very same day, my lord, next day. My lords, 48B, my second prayer, my lord. The point is this, my lord. Was the officer correct in fact imposing the order of detection? This assessee was in jail for 1 month.
Then you have to seek for damages.
It's not the, my lord, my point is this, my lord. Under similar circumstances, different courts have held the very order of detention itself is bad in law. We should not set a bad precedent, my lord. We are not looking into whether compensation or that's a different aspect, my lord. Whether such an arrest order was legal.
No, you seek.
My lord, this.
No, just one. Now you seek for appropriate prayer. Independently, we'll consider.
Can you kindly have it on 10th, my lord, Mr. Shankar?
No, but in this matter,
let them file a separate proceeding.
This matter, what survives insofar as if it's your contention that that though he is now free, you are to take appropriate proceedings against the officer concerned, or you're entitled for damages or any other declaration. You file it afresh, we'll consider.
Please, my lord, the scope of this. The court can hear me on whether the order was passed in an appropriate manner or not, so that this does not
Yes, you set a precedent that in future they don't,
No, correct, that we cannot get into a adjudication where matter is no more before the court by survival of cause of action. Cause of action is gone. However, if you feel that the procedure followed is wrong, you have to have an independent proceeding, which we'll consider.
can we take it up tomorrow, my lord? So that, let him have the, the assessee would like Mr. Shankar to,
No, correct, but what we are saying, we reserve liberty for you.
yeah, kindly, my lord. Yes, tomorrow or next week, what was convenient? to lord? On 10th, Wednesday. Just for a few minutes and then.
My humble submission would be, the scope of this writ petition is only.
Absolutely. Otherwise, I'll pass over by the end of the day, you make the motion.
At 2:30, my lord?
After 2:30, we have some parted matter. You can come anytime after 4.
Okay,
Pass over.
then kindly take it tomorrow, my lord, kindly, my lord. Kindly, my lord.
Release the matter tomorrow. Yes.
Deeply obliged.
36.
My lord, I appear for the petitioner.
Yes.
If I had pointed out last time, this is a petition challenging unauthorized recovery during the investigation proceeding under the GST Act covered by my lord's decision in Bundle. And Gland Chemical, the latest one. My Mr. Sandeep is there. He may pass on my compilation of judgment. My prayers are on page 57, my lords.
Yes.
My lords, the visit was made on 29th of July 21. Within 2 days, I was confined to my 150 square feet office for 2 days, and on the midnight of 2nd, I was asked to pay 1 crore by the Karnataka sales tax authorities. I have nothing to do with the Bangalore, but anyway, they came to my place. I attended to them. I gave all the details. I was summoned to come to Karnataka, Bangalore. I came on 2nd August. Again, I was directed to pay 1.5 crore. And my lord, I have pointed out in the petition, lordship may see page 21, I believe, where they could take out the sundry debtors where they were available, and then they called the sundry debtors and they called them that you pay the amount so that they can recover 1.5 crore from me. I'll point out that page, my lords. Para 46, it is stated. My lords may see page 21. Continues on page 22. My phone was also in their possession. It was not in my possession. He called the CFO of the company, MSN Group, and he told him to transfer the money to my account and then recover, made me file the challan. He only prepares the challan and he had to give the password, etc. That phone was also with him. My lord, today the investigation is going on. Show cause notice is issued. I am cooperating. The allegation was only with one party, Raj Chemical, with whom I had business for 2 decades. It continues to carry on business today also. I have all my evidence. Merit-wise, I have no issue whatsoever. My only complaint here, the only dispute I'm raising here is the unauthorized recovery during the proceeding under 67 and 70 of the GST Act, and it has to be refunded in terms of my lord's decision. May I refer my lord to the judgment at serial number 8? Only one judgment I would refer. That should be more than sufficient, my lord. Compilation I have given. Number of judgment on the same issue, my lords.
Yes.
Lordship may turn to para 19 on page 19 of the said judgment. And the conclusion my lords would find on page 27, para 28.
Yes.
Now, my lord, the only distinction, let me point out, this recovery was by Karnataka officer. I could not make refund application because I had no place of business in Karnataka also. I came immediately. They had no jurisdiction in any case. So I came immediately and approached my lords in September. My respectful submission, my lord, the money has lied with them for more than 3 years. That should be refunded to me immediately with the applicable interest.
Yes, your pleadings are complete.
Yes.
What
Things
is,
are complete. I have filed my detailed statement of objection.
what is the stand you're taking?
My lord, this is a bill trading. Invoices are generated without actual movement of goods. My lord, this was detected. And my lord, I have given my lord the narration in detail in my statement of objections. What was the modus operandi of these persons? And my lord, the authorities in Karnataka did not have a jurisdiction, even without any whispering anything on merits. My lord, the contention taken up by them in the writ petition. But my learned friend has, my lord, directly jumped to my lord, the judgments. Lordships, may I just request, my lord, to kindly peruse, my lord, the para 6 of my lord, my statement of objection in, my lord, ink page number 3.
What is the stage of investigation now?
I think, my lord, investigation, my lord, they made a submission that, my lord, show cause notice has been issued. I believe.
Issued.
Now it is under adjudication.
My lord, this is not a case of bill trading. The party is alive, trading today also, crores of rupees turnover.
No, I'm not, I didn't say that party is not existing. Parties are
My lord,
there. Goods are not
the
there.
bill trading
Only bills
persons are fly by night time. They are not the persons who are settled in the.
That is the, my lord, the investigation. They
Let
say
it
that,
be,
my
my
lord,
lord,
they
I'm
were
ready. I have
detained.
given my
My lord,
details.
all these amounts were paid through, my lord, the electronic system, my lord, under the GST. We did not, my lord, extract the, my lord, the money through a check or cash.
My lord, that's very
Newly
nice.
filled up challans were, my lord, presented and the amount was paid, provisionally agreeing to the, my lord, the defaults. Now, my lord, they contend that, my lord, it was coerced to make that payment. Lordships may, my lord, 5 and 6. My lord, there is no evidence of movement of vehicles carrying these goods.
Paragraph?
5 and 6, my lord. Four also. Well, I just read from 4, my lord.
Yes.
The response submit that the information was gathered by the officers of the DGGI. So and so regarding the violation of the act, and accordingly search was conducted at the premises of Raj Chemicals. During the search operation, the statement of so and so, one of the partners of Raj Chemicals, was recorded. In his statement, he has informed that the supplies made by Raj Chemicals to the entities located outside Delhi and Haryana from April 20 to June 21 are bogus, and invoices have been raised without actual supply of any goods. My lord, this is one entity where, my lord, they received the supply. In the statement, so explicitly mentioned the name of, so my lord, this is the petitioner, Kesar Kalan, as one of the entities which has received invoices without actual supply of any goods from so and so. On being asked about the RFID data of the vehicles used for the transportation by Raj Chemicals, showing that the vehicles have not moved at all or were moving in a different direction. So and so replied that they have generated EA bills on the basis of the vehicle details provided by the brokers, and as the goods have not actually been supplied, the vehicles would not have moved, and this could have been the reason for discrepancies. So and so. Based on the aforementioned information, search was conducted on the principal place and additional place of business. The principal place of business, so and so, my lord, in Mumbai. During the search of the said principal place of business, it was found that the premises is an empty land under redevelopment, and accordingly nil mahjar was done.
We'll continue.
Please.
But 2:30, there is 2:30, there is some part-heard matter. So I'll repeat it on the next tax roster day. Repeat it on the next tax roster day.
My lord, it would be next day.
Next Tuesday.
Uh,
Afternoon, I have some other matter.
My lords, no issue at all. My only request, let it be high on board, my lords. Or if my lords required, I can come personally also physically.
No, through video conference is okay. We'll have it at.
Fair enough, my lord, I am highly obliged.
Relist the matter on Wednesday at 2:30. Next
Obliged.
Wednesday at 2:30.
Obliged, my lords.
Tenth, my lord, tenth, please.
Mentioning at 2:30.
Obliged, my lords.
ಅಲ್ಲ 77 40 ಬಂತು 33 ಒಂದೊಂದೇ ಸಿಂಗಲ್ ಮ್ಯಾಟರ್ ಇದಾವಂತೆ ಅದಕ್ಕೆ ನಂಬರ್ ಕೊಡ್ತಾರೆ ಡಿಸ್ಪೋಸಲ್ ಆದ್ಮೇಲೆ ದಿನ ಹಾಕ್ಸ್ಬಿಡೋದು ಅಷ್ಟೇ ಡೈಲಿ ಹಾಕ್ಸ್ಬಿಡೋದು ಇದನ್ನ ಒನ್ ಡೇ ಕಂಪ್ಲೀಟು ಆದ್ಮೇಲೆ ಡಿಸ್ಪೋಸಲ್ ಆಗುತ್ತಲ್ವಾ ಈಗ ಮುಗಿಬೇಕು ಈಗ ನಿಮಗೆ ಈಗ ಒಂದೇ 2 ಪೇಜ್ ಅಷ್ಟೇ ಅದು 19 ವಿನಿತಾ ಯಾವ ಕೋಡ್ ಸರ್ 10 ಅದಕ್ಕೆ 22 ಬಜೆಟ್ ಇರೋದು ಅದಾದ್ಮೇಲೆ ಇನ್ನೊಂದು ಅಷ್ಟು ಹೋಗುತ್ತೆ ಇದು ಆದ್ಮೇಲೆ ತುಂಬಾ ಮ್ಯಾಟರ್ಗಳಿದೆ ಬಂತೆ ನೋಡಾಗ್ಲೇ ಈಗ ಒಂದು ಮೆಮೊ ಕೊಟ್ರು ಒಬ್ರು ಇದು ಮುಗಿದ ತಕ್ಷಣ ಇದೊಂದು ಹಾಕ್ಸ್ಕೋಬೇಕು ನಾಳೆಗೆ ಬ್ಯಾಚ್ ಅಲ್ಲ ಸಿಂಗಲ್ ಇದಾವೆಲ್ಲ ಈಗ ಹುಡುಕಿ ಇದು ಮುಗಿದ ತಕ್ಷಣ ಎಲ್ಲ ಇದು ಮಾಡ್ಕೊಳ್ಳೋದು $81 ಬರುತ್ತೆ ಎಲ್ಲ ವಿಡಿಯೋ ನಾಳೆ ನಾಡಿದ್ದು ಹಾಕ್ಕೊಳ್ಳೋದು ಇವತ್ತಿಗೆ ಇಷ್ಟು ಸಾಕು ಇವತ್ತಿಗೆ ಇಷ್ಟು ಸಾಕು ಇವತ್ತಿಗೆ ನಾಳೆ ಬೆಳಗ್ಗೆಯಿಂದ ಬೆಳಿಗ್ಗೆ ಬಂದು ಕುಂತ್ಕೊಂಡು ಕುತ್ಕೊಳಕ್ಕಾಗಿಲ್ಲ ಕೈಲಿ ಕಷ್ಟ ಆಗುತ್ತೆ
With my lords, kind leave, my lords, a fresh matter filed today, my lords. May I request for end of the list because without intimation of arrears, they've sought to recover the entire amount from my banker without even before expiry of mandatory 7 days, my lords.
Tomorrow.
Grateful.
Your Lordship, serial number 45.
40?
45, Your Lordship. The matter was almost heard yesterday. As per the direction, we have we have amended the prayer and also withdrawn the petition before CIT appeal, Your Lordship. That too we have filed before the court.
No, just wait, we'll consider. Let us see, I'll accommodate.
Serial number 38.
38.
The
Yes.
council says he is awaiting instructions still. To be taken up.
So we'll have it next week.
Next week. Possible on Tuesday, my lord, 9th.
Relist the matter on?
9th.
I tell you, 10th.
My lord, serial number 75, my lord. Serial number 75.
70?
Have it in next week, my lord. 75, my lord. Maybe on Tuesday, my lord, 9th.
75. Relist the matter on date.
May I please, Lord? Lord, seal number 77.
Yes.
Matter is posted today for hearing in the B group, Your Lordship. There is an urgency in this matter because the interim prayer itself has not been heard yet. If the matter could
See,
be-
wait, you wait, take a
Obliged.
chance, let us see.
Obliged.
If possible.
Number 2, my lords.
Huh?
Still number 2.
Huh.
Kindly be posted next Wednesday or Tuesday.
Relist the matter in the same stage on 9th.
And serial number 39, my lords, it may be called on.
10th, my lords.
39 after?
10th, 39 may be called on 16th, my lord.
39. Inform your.
Yeah, she's here.
This is the matter on 16th.
Fresh matter, my lords.
Serial
number 2, my lords.
2 I've.
My lords, maybe on 10th, my lords, not on 9th, my lords.
10th.
Obligement.
One fresh matter, my lords. Disciplinary inquiry has been initiated without issuance of notice.
Which roster?
Education.
No, this is a service matter, disciplinary
The
inquiry.
institute
No, disciplinary matters will come under service jurisdiction.
Great.
Further hearing, 230 matters, serial number 81, Raghavendra CR, Amit Deshpande, Jeevan Nirali.
I may be permitted to appear virtual, my lord, your lordship. Deeply obliged.
Yes, my lords, sir. I have been instructed on the what learned ASG has already proposed. I'd like to place my appreciation for the efforts being made by the learned ASG to sort matters like this across the country. In fact, the Tran 1 matters also, I think he took a personal interest and did this, and it was largely sorted out. I think we have to take that in a positive direction. That's my instructions are that we should try to find a way where, my lords, probably we can sort this matter out, subject to what lordships would, however, say. So there are two. I come straight to the subject matter as to how it probably could be done. There are two ways of doing it, my lords. One is that what used to be done in common matters earlier, sometime back when Justice Kumar used to pass, these are two matters which lordships will consider. I'm only suggesting. One is that my lords will have already heard us on this. Lordships would remember that I had suggested that the common miscellaneous order could be passed, keeping in mind what are the directions that should be followed. Lordships may probably hold. This is the approach. One would be where lordships would lay down what is the law, pass a common order, and then take up 5 matters at a time, or as your lordship's schedule would permit. Ask us where it fits in, ask the other parties if that is so, and dispose of the matter. This is one approach where the matters are kept here, directions are passed and disposed of at your lordship's end. This is one way of looking at it. This is obviously not what has been suggested, but this is one way of looking at it. Finally, lordships will have to take a call on that. The other way to look at it is what Mr. Venkatraman, the learned ASG, has suggested, where I have made a note on that, my lords. I would place it for your lordship's consideration. He can also see it. If Mr. Venkatraman's approach is adopted, then probably my lords would peruse this note. And if found appropriate, my lords, I think we can adopt this as a procedure.
Raghu, can somebody WhatsApp or mail it to me?
I'll do that. Sorry, Venkat.
No problem.
Send it by WhatsApp immediately.
I will send it.
I can follow it.
What you're saying, I think it's been sent to you.
Okay, I'll just check it up. WhatsApp, it has come. Yeah, you can go ahead.
Shall I? I'll read it out in case,
Please.
Shall I read this, my lords? In order to ensure that a just and quick disposal of the writ petitions is achieved, the following steps are suggested in the light of the ASG's proposal for sending the matters back for fair consideration on merits by designated officers and to keep all issues open, including point of jurisdiction. 1, the Honorable Court may direct setting up of a committee of 3 or 4 senior and responsible officers. This is what Mr. Venkatraman had suggested, who are well versed in adjudication of service tax matters, to examine the issues involved in the writ petition and submit a report. Now, this report will be given to your lordships.
The Honorable Court may pass a common order setting out detailed directions for the committee to perform their duties. These clear directions will ensure that the committee will perform their duties strictly in accordance with the court directions. The directions will be issued on the following aspects. These are the very aspects my lords would remember that we had argued and lordships were broadly in agreement with the categorization of the cases. One is where my lords, they do not qualify for service or negative list or the exemption list. Or should I read each one of them, my lords? Should I read it? Where the activities carried out by petitioner does not qualify to be service, to drop the proceedings at the same stage. In case services are covered under negative list, it could be dropped. If it's covered clearly by an exemption, the committee could take a decision to drop it. Where reverse charge is applicable and notice has been wrongly issued to the service provider, there also it could be dropped. Then there are two things. The limitation aspect should be wherever they've issued the extended period, directions may be given that they can follow the Supreme Court, High Court directions or orders in similar cases. Then, my lords, non-service of notice within time limit can also be verified. What we are suggesting, my lords, if the lordships could pass these directions, then the committee will consider within a time limit to be fixed by your lordships. Report back to your lordships on the verification, either in batches of 10 or 20 matters or whatever it is, or together, whatever is felt appropriate by your lordships. Then depending on the report, if the committee recommends dropping of some of the matters, that immediately orders could be passed in line with that. Wherever the committee does recommend that the matters cannot be dropped, then those matters only we can confine our attention to and start arguing on those matters, whether that should go back or not go back. Broadly, my lords, these are the two approaches that could be followed.
There's another way of looking at it. Another way of looking at it is in terms of the affidavit that they have given.
My lords,
they have stated that if the court were to order, they could be some designated officials and time limit prescribed for disposal. And in those matters where orders are already passed, in terms of the suggestion put forth in the affidavit, matters could go back to the stage of post show cause notice. One, and at that stage, they may consider all aspects, including what you have suggested of 6544, negative list, exemption, etc. And those matters at the show cause stage may also be sent back, because they've indicated broadly that they will look into these aspects, which we can notice in the order are matters to be considered apart from other contentions, and fix a time limit for the disposal. And this, they say, will be fast tracked, because upon suggestion of the court, it can be done by 3 or 4 officers, depending on the workload, which we can say, which will be a departure from jurisdictional, etc. And all contentions would be kept open at their end, and some of them may be closed. There ends the matter. Insofar as the others, including the aspect of jurisdiction, will keep it open, then you can come back afresh rather than keeping it here.
But what happens? I leave it entirely to your lordships, sir. I'm only looking at it this way. Should we come back again? I want to look at a mechanism where, my lords, all these petitions are pending 3 years, some 2 years, 4 years, whatever it is. This exercise, if your lordships directs to be completed within 2 months, then it can come back to your lordships and orders can be passed. We can close it within a period of 2 months. And if your lordships directions are there, then the authorities would be bound to pass orders in line with lordships directions. And let it be scrutinized by your lordships, only to see wherever it's dropped, the petitions can be allowed. Wherever it's not dropped, we argue, and lordships finds that there is some merit, as your lordships have been finding the past so many hearings. Lordship may pass appropriate orders. What I'm trying to do is only to hasten up the process and still be subject to your Lordship's guidance, so that the proceedings will go as per the directions of the court.
May I
That's
only-
all my, that's all my overarching consideration.
May I only say this, my lord? See, my lord, I think our trying to reach out should also not be overshot by my friends. See, the reason is this. If your lordship takes our affidavit, paragraph 9, the counter, the statement of objectives. See, in spite of this, we are trying to now find a solution. My friends can't be different from the rest. If you come to para 9, but as against 49,000 proposals given by the income tax department, without show cause, we have dropped 21,000, which is 43%. And post show cause, we have dropped close to 8,000 matters, 9,000 matters, 8,816. After hearing, we showed those orders also, reasoned orders. These 19,000 orders, only 75 are filed writ petitions, 70 or 75. Rest of them have all vindicated their rights in their own way, or it is abated, or they have paid. The majority is now going before the appellate remedies. Now to say we will give a special treatment of treating 75 cases here, then we'll be opening the floodgates. Everybody will now, from wherever the appeals are pending, they will now migrate into a writ petition and join this. Well, this is going to explode. And our record is not so bad. 61% we have dropped. But we can't be doubted. We can. This is virtually putting us on the, as though we need, my lord, your lordship's surveillance for us, our officers to work. Well, this is unacceptable. This is not fair also. What
No,
are we
let us-
saying?
Yes.
Yeah. Yeah.
No.
So what are you saying is, Lord, please send it back. Let them have they have come to the court, and we also want to settle. There can be plus or minuses. Let them go back. Please fix the same 2 months, 3 months time limit and give a direction. We'll ask responsible officers to immediately act. Lord, your lordship need not have to say whether it's exempted or not. If it is, we have shown orders. Lord, the whole problem I am instructed to say is, wherever the assessee, unmindful of whether it's a good show cause or bad show cause, has chosen to participate and give the proper details, proceedings have been dropped. Wherever they think they can take, no, you have no right to issue show cause and not participated, proceedings have been confirmed. These are the two broad. To say that you can't issue a show cause notice at all, that is something which is not acceptable. So let them participate, show the evidence. And we have dropped in 30,000 cases. Will we not drop the 75 if it's going to merit consideration? Have that faith on us, my lord, and please send it back. We don't want any other arrangement, my lord. That's a very, very humble request we want to make.
I think finally, the question of jurisdiction will be kept open expressly. Now, if in most of the matters, it looks like on merits, bare perusal would be the SSCs have claimed either it's in the negative list, reverse charge mechanism, or exempt, broadly speaking.
Let them
in
show
most
that.
of the cases, that is the contention taken. Now, only in matters which may require some adjudication, the question of jurisdiction may have to be gone into. If on merits, in most of the cases, relief is going to be extended, then we would leave it at that. In those few matters in which there is some denial of relief, the doors are always open, the rider is there.
And that is exactly what I'm also saying. I'm only saying this, my lords. I do not know why the learned age is taken it in a different way. I'm saying the same thing, except I'm saying this. This exercise, I'm sorry to say, my lords, as per their own circular, should have been done prior to issue of show cause notice. As lordships will know, what Mark Twain said about statistics, I don't need to say it.
No,
1 minute, Raghu. Lord, we have.
You don't want to say it.
No,
I'm saying this.
I'll just
Let me finish. Let me finish, my lords. Let me finish, please. Let me finish. I am saying this exercise having not been done before the show cause notices were issued, and the board being very well aware of this. It's very clear that if it falls in, all that we are saying is binding directions to be issued, let them do this exercise, come back here and report to the court, and there's nothing wrong with that, because after all, we have approached this court and knocked the doors of this court. This court has not found that this is the petitions are without jurisdiction. Jurisdiction is a question which is anyway open to this court. if the committee has decided to drop some matters, so be it. If they decided to confirm the matters, let it be tested on the touchstone of jurisdiction. Lordships must still send it back. That's all I'm saying. I'm saying, having waited for 3-4 years,
That's all I'm
at least the
disagreeing.
assessee should have something.
But I am
It
disagreeing
can't be
with the
sent back
record.
to the whims and fancies of the very authorities
That's
who have
wrong.
passed orders in this manner. man.
Please go on
Or
record.
issued show cause notice. This
No,
is
I
all
think,
yes.
well, I will have to oppose it. We are trying to be very soft.
No,
We
I
are trying
think-
to be very, very
I think
methodical.
I'll intervene.
But-
No, I think I'll intervene at this stage.
Yes.
So what I'm saying, rather than pushing it further, some midway, of course, it may not be to the satisfaction of all, but I think we can accept their proposal. And this question of jurisdiction in maybe in 10% of the cases, if it does affect, they can come back. We leave it open. We leave it open. That's a midway without entering into adjudication. The fact that this will involve a expeditious thing is by virtue of a time limit being given, and that they will nominate 3 or 4 officers to take up these cases on priority. So that will.
Not all that. I'm also saying the same thing, my lords.
I want to wash my hands for the present. Nevertheless,
My lords, that is precisely what we don't want to happen.
No, we will. I make it.
I'm making it clear. I can't make it clearer than this, my lords.
It may come back. It may come back. Let us see.
My lords, I am only making, this is my fervent request to your lordships. Please keep it pending for 2 months till they give a batch of at least 5 or 10 matters. If your lordships is convinced with that, then let it go back completely. This is all that I'm saying, my lords.
But we have
Let us test this proposition. We have to test any proposition.
Sorry, my lord. I'm sorry. But our impeccable record shows that we have been too lenient and too good. 30,000 cases we have dropped.
I would like to.
We don't want to be going through the guillotine, my lord. We can't be going through the guillotine at the whims of the advocates.
My lord, that is to say, my lords, if the matters go back to the authorities, and the assessees can go to the guillotine. But if the authorities are subjected to the directions of the court,
this is unfair.
then it is guillotine. I'm sorry, I don't accept this.
But I don't know. I'm extremely sorry. I'm extremely sorry, Mr. Raghu, to say that officers are bad in a constitutional court. But this is mistrust. Please, please, in the light of para 9 of our affidavit, but we can't take it too far.
Please see this
affidavit. Very
affidavit.
Unfortunate. To mistrust officers is not a wrong order can be
It's not a question of mistrust. I am only saying only this. No, it's not a question of mistrust. It is only a question of ensuring that the directions of the court are complied with, which is a fair thing. If supposing lordships were to pass a direction against me, it is but fair that I should comply with it and report to the court. How are the officers different from me?
30,000 orders we have dropped. And
my
the
lord, this is
orders they are in
my lord,
Your lordship may record our statistics. 1 minute, Mr. Raghu. Please record our statistics on the order, my lord. And your lordship may pass an order. We'll see wherever it goes. Where do you have to go? See, 30,000 cases have been dropped. And 20,000 cases are pending in appeal. 70 petitioners are taking the whole department for ransom. We can't take it.
Just one.
I'll make one submission, my lords.
Just one.
Is this matter to be fought on statistics or on legal grounds?
It has to be fought on statistics. No, you are touching on credibility. It has to be fought on statistics.
No, we can do one thing. No, I think
jurisdiction is that, my dear.
No, subject.
My dear, jurisdiction is that.
Now, subject to what both of you say, I think we can just leave it at that. I assure you that their assurance from that they will take it up positively, we can give some credence to that. Now, in the event somebody suffers on jurisdiction, doors are always open. We can come back. Hopefully, that would be a small percentage of the entirety. We leave it at that. Let us see how it goes.
We leave it entirely to your lordships. We are not going to say anything. All that we're saying is this is the apprehensions that this is not 1 or 2 assessees. This is about 100 assessees across. And your lordships have seen the quality of notices or orders and or orders which have been passed. Your lordships have seen it. I have nothing more to say. I am only to say that my lords, that if this were subject to your lordships, at least lordships may pass directions how this is to be done. Because
I'll make some observations.
My lords, if your lordships were not going to give binding directions, we will be back to square one.
No, I'll make some observations for which the other side has no objections.
Yeah.
My lords, even
If
I
you
would
please.
say this, all this, what we have set out, they have to adhere to this. Otherwise, the very
That is well
purpose
taken.
of this
No, no,
writ
yeah.
petitions would be defeated.
Your point regarding negative list, exemption, etc., well taken. I will make observations. They have no objections for
Yeah.
that to be taken note of at the time of disposal by the officers.
Yes.
Yes, so I'll proceed to dispose it off. Now, the only point is in those matters where appeals are pending, what happens in those matters? Yes, Mr. Venkatraman, where appeals are pending.
But if they have filed, my lord, I'm also in the crossroad. Your lordship may do one thing.
Yes.
Having come, my lord, please do it as an exception. Having come to the
Yes, yes.
report, please quash all these orders and send it back to the show cause. Let them go and withdraw the appeal. But my lord, please say that because it is a whole batch, this should not be cited as a precedent. I don't want, my lord,
Yes,
tomorrow
yes.
to take their chances. They will file an appeal, come on a writ court and travel for years. But we
Yes.
don't want that because it's a whole cluster. A cluster order is, please ring fence it so that my friends do not, my lord, use this as a caveat every time.
Yes, yes.
Deeply obliged.
Wherever applicable, my lords, where appeals have been filed,
They will.
lordships can give a direction that it should be withdrawn and wherever applicable. If they don't withdraw, my lords, then the matters don't even go for a re-adjudication. It remains there. Simple as that.
Deeply obliged, your lordship.
Yes.
I'm not able to hear the council, my lord.
Come, use the mic, use the mic.
Let me also see you.
Now, what we can do,
Yes, my lord. Inside there. The court video is frozen, my lord.
I'll pass that skeleton order, then you make a mention, we'll see. These petitions have been filed, calling in question the action of the respondents department in issuing show cause notices or having passed orders in original relating to demand sought to be raised with respect to under the provisions of the Finance Act 1994 relating to service tax liability. After having heard the matter on various occasions, the Union of India have taken a stand and filed affidavit of the Principal Commissioner of Central Tax. Full stop. The DSG was present before the court on dash had stated that
27 June and
on 27 June 2024 had submitted that they desire that the matters be resolved and accordingly have put forth a proposed mechanism and made certain suggestions in the affidavit filed. The relevant extracts of the affidavit filed reads as hereunder. After learned Senior Counsel Sri Raghuraman has also filed a note in response to the proposal, and same is taken on record. Next. After hearing both sides and though certain issues were raised, however, both sides have made a submission that the court could take note of the affidavit and pass appropriate orders. Accordingly, the following order. Taking note of the affidavit filed, it is made clear that wherever orders in original have been passed, the said orders in original would stand set aside and matter remitted to the stage of post show cause notice. In so far as other matters are concerned, which at the stage of show cause notices have come before this court by way of the present writ petitions, matters would stand remitted to the stage post show cause notice. Next, it is upon the suggestion of the court, the union, the ASG has responded positively by stating that if a team of how many officers?
But your lordship may say 4 or 5, depending on the need, my lord. A team of officers to within a time limit. I'm not able to give the number, but a team of officers.
A team of officers
Specifically
who are competent to pass orders across, though without reference to the territorial jurisdiction, would be constituted at to implement the to pass necessary orders from the stage of post show cause notice, which would be done within a period of
3 months will be fine, my lord. My friends agree there.
Within a period of 3 months. 3 months. Full stop. Next, needless to state, where perusal of all the petitions have raised various contentions, some of which are required to be referred so that the officers concerned may take note of the same while disposing of the proceedings at the stage of post show cause notice. Full stop. The officers, while disposing of the show cause notices, to keep in mind the following as to whether petitioners qualify as service under 65
B44 it should be, ma'am. Should be 65 B44.
65 B44 of Finance Act 1994, comma, whether services are covered under the negative list under section 66D of the Finance Act 1994, comma, whether services are covered under the exemption list as per notification 25/2012-ST dated 28/6/2012 or under any other applicable notification, comma, whether the person liable to remit service tax as to who is the person liable to remit service tax in terms of Rule 21D, comma, the aspect as to whether the claims are barred by limitation in terms of the law laid down by the Apex Court, comma, what is the last F1? What is the F?
Lord, the notice itself has not been served. I am told that there are some cases where notice is not served and orders are passed. There is no service of notice. Then if there is no service of notice, what is to be done? That has to be taken into account.
And the officers may also look into such of the matters where there is non-service of notice. Next, it's also clarified that in light of an exception being made for disposal of the present batch of matters, and that such exception ought not, it is clarified, would not operate as a precedent, and further it is clarified that the disposal of the present petition must not be construed as having adjudicated on any issue including that of jurisdiction. All contention of both sides on merits are kept open.
Extremely obliged, my lord. We can't ask for more. Deeply obliged, my lord. I'm thankful to my friends
Liberty
also.
will be granted to us to approach the court if we are aggrieved.
Needless to state, upon conclusion of proceeding, if any of the petitioners are still aggrieved, the legal remedies available are kept open in accordance with law. Yes, now the exceptions. You can come to the mic, use the mic.
My lord, serial number 81.17, my lord.
81.17,
my lord. WP number 25126 of 2022.
2516.
126, my lord.
Yes.
My lord, in this case, my lord, the petitioner was expired on 11/9/2018.
Yes.
Then so-called notice was issued on 23/4/21.
No, then we will.
Order in so-called notice itself issued on the name of the dead person.
No, so we'll delink it and we'll take it up.
Yes, my lord.
This matter we can be delinked.
Yes, my lord.
And we'll take it up.
Please, my lord.
81.17 to be delinked and taken separately in light of contention raised by the council. Yes.
It's not necessarily an exception, but what's happened in some cases pursuant to the orders in original, recovery letters or bank attachment has been done. My lordship may clarify that those orders or subsequent letters are also set aside consequent to the orders in original.
Yes, yes.
That
Lord,
that
Lordship
letter
may
will
say
subsist.
cease.
Yes.
The Lordship may say ineffective rather than setting aside. Ineffective.
Please. Or all consequential proceedings for recovery may also be settled. I leave it to my lord.
One sentence.
Yeah.
ಅಲ್ಲಿ orders in original ಅಂತ ಹೇಳ್ತಾರೆ. Further, it is clarified that all proceedings pursuant to the order in original would also be unenforceable in light of disposal as observed above. Yes.
Identical case also, my lord, I have given a list, 2 cases of advocates can be listed tomorrow in the lines of the same order.
Yes.
I to the court officer.
If now the only point is, we don't know if the registry has put up all the other matters. There were one more batch.
Yeah, can it be listed, my lord? My friends can even, so I don't have to be.
Yes, yes. So we will direct the registry to list it and then let your officers.
Yes, my colleagues can. I'm extremely obliged to all my friends. And when Raghu complimented, I was feeling happy. Then I understood it's a needle to be pierced slowly into the banana.
That is, Venkat, you know what Mark Twain said, no?
Yeah.
Lies, damned lies and statistics.
Well, I'm appreciative of my friends and extremely thankful to your lordships for the indulgence shown. We'll solve the problem. We are sure, my lord, we'll try to do the best legal resolution.
My lord, serial number.
Separate list. The other matters.
Yes, sir, I have given one list.
The batch. List you give it, we'll have it put on one day so that to avoid confusion.
This 3 months, my lord,
Only one matter I have
clarify
given, not a batch.
whether it's from today or from date of receipt.
I'll clarify in the order.
ಮಂಜಾಣ ಒಂದೇ matter, ನಾಳೆ.
Yes. My lord, serial number 60, my lord.
If there's anything we have to submit, my lords, we could be given. Time
Liberties.
could be fixed by your lordships. Once the committee is set up,
Yes.
then lordship may say committee can be set up within.
No, it's not a committee, my lord. Individual officers will do it. We'll have, my lord, don't worry, but we'll give them time within, and your lordship can say they file a reply within appropriate time. No difficulty. Please add that. Please add.
Needless to state, the petitioners who are now relegated before the authorities concerned are at liberty to file their pleadings within a reasonable time as may be fixed by the officers before whom they appear.
Extremely obliged, my lord.
Yes.
Can I exit, my lord, from your lordship's
Yes,
court?
yes.
Keep you obliged.
Lords, with hearing opportunity also.
I'll refer. That's why Mr. Venkatraman wants to exit fast.
Because next he will say, please add, also compulsorily drop the matter.
My lords, I would urge not to exit because I'll add something after he has exited.
Yes, yes.
Obliged, my lord, obliged.
Continue, madam. Continue, madam.
82, Pradeep Nayak.
ಅದು ಒಂದೇ ಇದೆ ನಾಳೆ ರಿಪೀಟಿಂಗ್ ಮೆಮೊ.
Just 1 minute, just 1 minute. Now, I'll continue the list till 4 o'clock and then come to the 2:30 list.
Very
I'll continue the list till 4 o'clock and then come to the 2:30 because some matters have not yet reached.
There are matters may not stay meeting.
Yes, yes.
Indicate.
Yes,
I'll wait these matters are coming.
yes.
Public.
You continue, madam.
38 urgent, 39. Another Emma, 39.
ಅಲ್ಲ
39.
ಅರ್ಜೆಂಟ್ ಆಯ್ತು. ತಿರುಮಲೇಶ್ವರ ಅರ್ಜೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. ಕೇಳು ಪ್ರಕಾಶ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
39. 39.
39 ಅರ್ಜೆಂಟ್ ಆಗಿದೆ.
39 is adjourned.
Emma,
Just
Tirumalaish took time.
39 is ಅರ್ಜೆಂಟ್ ಆಗಿದೆ.
40. Number 40.
This also pertains to income tax issue, my lord. I've given it in the list, my lord, for getting it tagged for with the
Okay.
and serial number 60, your lordship.
Just 40 service tax. ಈ ಲಿಸ್ಟ್ ಇದೆ. ಅದು 60 ಆ ಲಿಸ್ಟ್ ಸೆಪರೇಟೆಡ್. Now 40 can be added to the same list.
Yes, your lord.
Same list.
Yes, your lord. This is an exemption. It was the transportation of goods. My lord said provided this date because it was clearly exempted.
40 list along with the group.
Yes, your lord. And serial number 60 also, your lordship.
Serial number
60, your lordship.
60.
It's still not been admitted, your lordship. That's also pertaining to show cause notice issued on the income tax return.
40. This one like
On the basis of
Same party na.
different party.
Copy. This is
That otherwise let them, you serve a copy, let it come in the separate list which we are going to.
Oblige.
I take.
And then
Please.
what you could do is you can just make one table for the purpose
will
of clarification by sitting together that in how many order and original is passed,
Yes.
how many are still at the stage of show cause notice.
Yes.
Huh?
Yes, yes. That can be done.
ಆಮೇಲೆ ಇನ್ನೊಂದು ಒಂದು ನಿಮಿಷ ಪ್ರಕಾಶ್ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಆಡ್ ಮಾಡಿ ಪ್ರೀವಿಯಸ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಒಂದು ಸೆಂಟೆನ್ಸ್ ವೆರೆವರ್ ಮ್ಯಾಟರ್ಸ್ ಆರ್ ಪೆಂಡಿಂಗ್ ಇನ್ ಅಪೀಲ್ in light of the arrangement that is made, the petitioners to file memos for withdrawal and accordingly the orders in original in question would also receive the same treatment as per the directions made above.
This 81.17 was delinked, my lord. That interim order may be extended.
81.17 delinked and interim
81.
order earlier granted is extended till the next day.
Please, much obliged.
40 along with that batch. Disposed along with that batch. List along with that 230 ಮಾಡಿ ಅದು dispose.
41. Serial number 41. Shankaregoda ML.
41.
Connect ಮಾಡ್ಬಿಡ್ಬೇಕಲ್ಲ. Connect ಮಾಡ್ಬಿಡ್ಬೇಕು.
Yes.
My lords, the petitioner is challenging, my lords, the order passed by the first respondent under section 130, my lords.
ಈಗ ಇದನ್ನ ಇಲ್ಲಿ ಕನೆಕ್ಟ್ ಮಾಡ್ತಿಲ್ಲ.
Section
130, my lords.
ಆಯ್ತು.
In the annexure W, my lords, page number 60, that is, your lordship will find it in the amended application filed for the amendment of the petition, my lords.
Annexure,
W, my lords. Application for amendment has been filed.
the one ನಿಮಿಷ ತೋರಿಸಿ. ಇದನ್ನು ಇದಿರ್ಬೇಕು, amended petition.
Amended petition.
ಇದನ್ನು ತೋರಿಸಿ.
ಇದೆಯಾ?
Yes.
This is an order passed under section 130, my lords, for confiscation of goods
Yes.
on various grounds, my lords. Your lordship may kindly see.
Now, who appears in this? Yes.
Your lordship may kindly see. Next year, E, page number 26, my lords.
Yes.
This was the goods conveyance was intercepted on 27/2/2024. Which was carrying the melted, remelted lead, my lords. On the interception of the vehicle, my lords,
No, now here interim orders not yet granted in this.
not yet granted.
Not yet.
my lord.
Original petition was filed challenging the notice issued under section 130, for which we filed our objections. The matter was listed before for consideration of interim prayer, and this honorable court, my lords, on 2/5/2024. Has been pleased to pass this following on 2/5/2024. In fact, our main objections to the original writ petition was that it was only against a show cause notice. They can file the reply to the show cause notice, and writ petition is not maintainable.
Now the matter is decided, is it?
Now the matter is decided. Now an order under section 130 has been passed, which is at page 60 of the amendment application. Now, my first objection is this is an appealable order, and they have not complied with the terms of the interim order that is passed by this honorable court. They could be put on the same terms. Let them furnish a bank guarantee, get their goods released. Let them file an appeal as provided in 107 minutes, because a lot of factual positions are involved in this matter. It is not the matter of jurisdiction, or it is not the matter of not being heard or personal hearing not being granted. Here, my lords, there is a concern and consignee. Goods are being transported on one particular document. The main allegation that is made by the officer is that the person who is supposed to have supplied the goods to the petitioner is not an existence dealer. That is one Bhushan Traders. Going further, my lords, they have verified the vehicle has not even gone to the address that they have mentioned in the e-way bill. And my lords, no payments have been made by the petitioner to Bhushan Traders. All this have to be verified, my lords. This has to go before the first appellate authority because factual positions are involved.
Yes.
May I make a submission? My lords, firstly, the petitioner is challenging the MOE 04, that is physical verification report, which has been prepared which has been drawn beyond the time limit which has been fixed under section 129 read with rule 138C and also read with the circular, my lords. Therefore, all subsequent events are illegal and therefore including the notice under section 130 and also the order passed under section 130 are bad, my lords. Your lordship may kindly, secondly, your lordship may kindly see, as per physical verification report and detention report, and also in the notice and also in the order, your lordship will find, may I take your lordships to the physical verification report, my lords, which your lordships will find Annexure H to the original petition, my lords, page number 33. Annexure H, my lords.
If it requires hearing, then we'll have it some other day. We'll hear the matter.
It will need some time, my lords. Can be taken up around 2:30 now.
Pleadings are complete.
Pleadings are complete. Like my lords, it will be convenient if my learned senior furnishes an amendment writ petition along with annexures. Otherwise, I'll have to refer to original writ petition, then the amended application.
No, amended petition has been filed. my
Amended
lords.
petitions with annexures.
It has been filed, amended.
It doesn't contain annexures. I don't want to make such a this thing, but it will be convenient for the court as well as for me to follow.
Amended petition has been filed as per my.
Now, to the court, he has given. He's given it to the court.
Then I'll compile it myself.
No, that he.
What is the limbo copy quote?
That he'll give it to you.
Amended writ petition.
Yes. 2:30 and 3 hours. 16th at 2:30. 16th.
Please.
16th at 2:30.
You can connect with
16th at 2:30.
42, serial number 42. Lakshmi Madam.
Yes.
Lordship, I pray for time, Your Lordship.
At request.
Interim order may be extended, Your Lordship.
Week's time granted to take fresh steps as regards R5. Interim order earlier granted is extended till the next day.
That will take out notice on respondent number 5, I think.
Yes. Release the matter.
Who's a necessary party to the petition.
Yes. Now here, objections are to be filed. Objections are to be filed.
Central government is answering.
Objections will have to be filed.
Statement of objections to be filed. Is the matter after 3 weeks. Yes.
43,
And then,
43.
my lord, I have this.
Given near like this is.
My lord, this is with regard to, my lord, interest on refund, where, my lord, awarded by the authority. Appeal also, my lord, confirmed. Original authority denied the interest. My lord, appellate authority, my lord, set aside that order of the original authority and directed the department to pay interest on the, my lord, the refund. Lordships may, my lord, kindly peruse, my lord, synopsis, where the refund application is not honored within 60 days from the date of application. My lord, the department is liable to, my lord, pay interest on that.
performance ಆದ್ರೆ ತಗೊಳ್ತಾರೆ.
Just come again, if the
60 days, my lord, is the time under section 56 of the CGST Act. 60 days is the time granted to, my lord, the grant refund. Now, my lord, after the expiry of 60 days, my lord, department is liable to pay interest on the further delay. Now, in this case, my lord, there was a earlier orders, and my lord, in consequence of the earlier orders, now, my lord, against that earlier order, my lord, they have filed an appeal before the Commissioner Appeals. Now, after the Commissioner Appeals, my lord, confirms, my lord, set aside the order and directed the department to give a refund. From that date, in consequence of that appellate order, my lord, he makes an application for refund. Now, from that date, the date on when, my lord, he made an application, within 60 days, my lord, the refund was granted to him. Now, my lord, he makes an application for interest also subsequently. That came to be rejected. Against that, my lord, again, he prefers an appeal. The appellate authority, my lord, directs me to grant an interest. Though I had given, my lord, a refund within 60 days from the date of the application, where he says that earlier refund application, which was originally filed, which was rejected, and, my lord, in challenging that, where the assessee preferred an appeal, that earlier application had to be considered as an date of application, not the, my lord, the application which was filed in consequence of the appellate order. That is the, my lord, the issue.
in light of the contention raised that the grant of interest can be only from the date when it becomes due upon all
Application.
proceedings having attained finality.
Final, my lord, in consequence of the orders, my lord, that's appellate orders
In Vajradhara.
under section 56.
After proceedings have attained finality, there would be an interim order of stay of,
There is no, my lord, interim order, my lord, I just.
he is directed to must issue notice.
Lordship may kindly issue notice.
Must issue notice. Issue
There
notice.
no,
to
we
the-
did not seek any.
Issue notice to the respondent. Office objection. Beredu. Office objections to be complied with in the interregnum.
Yes.
Yes.
44. 44. Balram.
Your Lordship, less than
Amendment.
7 days. Issue.
Yes, yes.
This matter had come up yesterday. Was annexure A, my lords, page 30.
Page
Page 30.
Answer put up.
30.
Please, I put that.
Yes.
Shoko 148 AB notice is, my lords, dated 28th March 2022. However, it was digitally signed and sent on the next day, following day. So it is less than 7 days. Lordships may, has to be allowed. So we verified, it was sent only on 29. But it's less than 7 days.
Four. Okay. Date of notice is?
Date of notice is 28th March, my lords.
Yes.
But it was sent on 29th March.
Sent on 29.
It was signed also on 29th. Signed and sent. Lords will get, my lords, at page 32.
The question.
Lords,
question mark.
please, my lords. It was signed on 29th.
Yes. The
Lordship, I prepared small synopsis I prepared.
the petitioner has challenged the validity of the order at annexure B under 148 and 148 capital A small d, as well as notice under 148 at annexure C, comma, the order under 147 read with section 144, read with section 144 capital B at annexure L, comma, the demand notice at annexure M, order at annexure L, demand notice at annexure M, the order at annexure L, and demand at annexure M. Full stop. The case of the petitioner that the notice under 148 capital A small b was issued which was dated 28/3/2022. Full stop. Is however submitted that the said notice was digitally signed only on 29/3/2022, and accordingly the date of issuance is to be taken as 29/3/2022. Full stop. Further submitted that the time given to reply.
My lords may kindly consider to, my lords, mention the time also, my lords, because 29th March 2022, my lords, at 4:35 PM it was sent.
At 4:35 PM. Full stop. It is submitted that the reply was required to be made by
4/4/2022.
By 4/4/2022. And in light of the time that was made available to make out a reply being 6 days, the notice under 148 capital A small b requires to be set aside as being in violation of the statutory mandate under 148 capital A small b, as not having afforded period for making out of reply, which ought to be not less than 7 days. Submitted that by virtue of the short time made available, the petitioner was prejudiced and there has been violation of principles of natural justice, and accordingly relief as sought for is requested to be granted. Next, it is noticed that the notice at annexure A under 148 capital A small b, though is dated 28/3/22, was digitally signed on 29th of March as verified and submitted by Council for the Revenue. If that were to be so, response to be made within 4/4/2022 would amount to calling upon the petitioner to make a response within a period of 6 days, even if it is assumed that the notice was served on 29/3/2022 itself. Section 148 small b reads as follows. Next, in light of non-compliance to the time limit required, it can be taken that the contention of the petitioner that he has been prejudiced by non-granting of 7 days time requires to be accepted in light of the statutory mandate under 148 capital A small b.
Its liberty may be reserved.
Accordingly, on such sole ground, the notice under 148 capital A small b is set aside, and consequently the order at annexure B and the notice at annexure C and order at L and M are set aside. order at L and notice at M are set aside. Full stop. Respondents are reserved liberty to take action regarding the subject matter of notice that is set aside if permissible as per law. All contentions are kept open.
45. Serial number
Your
45.
Lordship, Your Lordship, here in this matter, the assessing officer has passed the order without considering the valuation report, Your Lordship. Yesterday's matter,
Yes.
so we have amended the prayer, Your Lordship, here. Assessment order is in page 35.
Yes. Relevant page?
35, Your Lordship, Annexure D.
No, correct. Relevant page. Relevant page.
Relevant page 39, Your Lordship, para 8. Last para, Your Lordship,
Yes, yes.
13th line.
Yes.
Hence, considering the point as mentioned above, not satisfied with the reply furnished by the SSC and with a view to have a clear picture before making the final assessment, a reference was made to DVO under section 142A of the Act for ascertaining the fair market value of the property. Further, it is mentioned that since that matter has been already referred to DVO, the report from whom is yet to be received.
Yes.
Hence, this order is subject to modification as per appropriate provision of Income Tax Act.
Yes, yes.
Therefore,
Yes.
yes.
My lords, without waiting for the DVO's report, my lords, we passed the order. Your lordships may kindly consider to set aside, my lords, let them consider the DVO's order, and my lords, they filed an appeal. My lords, they've filed an IAM in the amended writ petition. They've undertaken to withdraw that. Lordships may kindly consider that and demand it back.
IA 3 of 24 has been filed seeking to the amendment application in Manjunath. The 22nd June. Yesterday you have filed, is it?
Yes, Your Lordship.
You have the office copy of that amendment. The petitioner has filed an application seeking amendment of the petition. In light of the submission made, the application is allowed necessary amendment to be carried out to the petition. Counsel for the petitioner submits that the grounds insofar as the amended relief sought for are based on the pleadings already on record, and the same may be taken note of. The order sheet ಅಲ್ಲಿ the petitioner has called in question the validity of the order in original at Annexure D by virtue of the amended prayer. The counsel for the petitioner submits that while proceedings regarding capital gains out of certain transactions for the subject matter of consideration before the assessing officer during the course of the assessment proceedings, not being satisfied by reply of the SSC, and in order to have a clearer picture of valuation, reference was made to
TVO, District Valuation
TVO.
Officer.
District Valuation Officer under Section 142 capital A of the Act for ascertaining the fair market value of the property. It is submitted that without waiting for the report of the District Valuation Officer, the assessing officer proceeds to conclude the assessment, taking note of a certain value of the property, which according to the petitioner could not have been resorted to. And accordingly, it is submitted that on such sole ground, the impugned assessment order is required to be set aside. Next. Lord Counsel for the Revenue is unable to controvert the assertion of the petitioner as regards the assessing officer not having waited for the receipt of the report by the district valuation officer. While passing the assessment order, it is clearly observed that the assessing officer has referred for valuation to the district valuation officer under Section 142 capital A of the Act for ascertaining the fair market value of property. If that were to be so, the question of proceeding while taking valuation of property as was earlier to be taken, as was, how did he take, what is the value he took?
Yes,
Yes, how has he taken the value now?
Your Lordship, he has just taken on estimated basis, Your Lordship,
Yes.
the value.
Yes, yes. In Bardida. By taking the estimated valuation would be impermissible, as the same would amount to acting on surmise. Full stop. The assessing officer, once having referred the matter for valuation to the district valuation officer, ought to have waited for such report and thereafter concluded the assessment proceedings. Next, accordingly, in light of the above, the assessment order is set aside, matters remitted for fresh consideration, with the observation that the assessing officer is required to await the report of the district valuation officer, and after obtaining it, to share the said report with the SSC, provide an opportunity for the SSC to take its stand as regards such valuation and proceed further after affording sufficient opportunity to the petitioner. Full stop. Accordingly, the petition is disposed. Order at Annexure D is set aside. The consequential proceedings for recovery by way of attachment, by way of
Please, no Lord.
Attachment. Yes, Annexure F and F2, Your Lordship.
by
Page
way of
59.
attachment in terms of annexure
F and F2, Your Lordship.
F1 and F2
Yes, Your Lordship.
are
Page.
set aside. All contentions are kept to merits. Necessary amendment to be carried out forthwith.
Much obliged.
46.
Yes. 46.
This is an income tax matter for assessment year 16-17. Two issues, Jonas. Apart from the legal issue of being less than 7 days, the income assessed is less than 50 lakhs, which I have demonstrated to the assessing officer at the stage of 148 AB itself. I'll just take your honors to the 148 AB notice first. Page 47, Annexure A.
Yes, income tax.
Sanmati is logged in.
Your
online.
Lordship, I will take notice for the respondent, my lord.
Notice is already served. You already served copies.
I have received the copy, my lord. I will get instruction, my lord. Your Lordship, this is for the assessment year, my lord, the 2016-17 one.
Yes.
Your Lordship, the matter is pending in Supreme Court as far as the instruction number 1 of 22 is concerned, my lord. And in similar matter, stay has been granted.
Your Honor's short point is, if it is beyond 3 years, can they do a reopening? That's all. Here I have demonstrated the income is less than 50 lakhs. He said, I will verify the 54F claim. When it is before less than 50 lakhs, there is nothing to verify. That is the short point. We are not on the instruction. Whether they could open it. 148 AB stage, I filed documents. I said the income is less than 50 lakhs. He proceeds and still makes the addition.
That is for the extended period, it should be less than 50 lakhs.
Yes, Your Honors. Beyond 3 years, it cannot be more. It should be excess of 50 lakhs, but here it is less than 50 lakhs.
What do you say regarding that?
Your Lordship, Your Lordship, we are relying upon 1 of 22, my lord. Our, as per the contention of the revenue, it is beyond 4 years and within 6 years, my lord.
Notices issued on 3rd March 23. They cannot rely on the 21 act prior to 21. And even 23 also, 16-17.
For assessment year 2016-17, my lord, whether the department can rely upon 1 of 22 or not, that is the question. That on basis of that one only, the notices have been issued. I will get instruction, my lord. Let there be a interim production, my lord.
I leave it to Your Honors. It's a short point. I leave it to you.
In light of the contention raised, stating that the proceedings are time barred, considering that the income that has escaped assessment is less than 50 lakhs. Subject to further consideration, there would be stay of
Annexure A to A6, Your Honors.
Annexure A to A6. Learned Counsel, yeah, 46, 46. But Sanmati is directed to accept notice for the.
It is already served, Your Honors.
Office to delete the name of Learned Counsel, Shamant Naik.
Please, oblige. 47.
My lords, the petitioner has challenged the order passed under section 73(9), my lords. The lordship will find it in Annexure E, page number 18. On the ground that, my lords, as per section 5, subsection 2 of the KGST Act, my lords,
KGST Act. Section
5 and 5, my lords.
Yes.
My lords, subsection 1, my lords, subject to such conditions and limitations as the commissioner may impose, an officer of a state tax may exercise the powers and discharge the duties conferred or imposed on him under this act. Subsection 2, your lordship may kindly see, this is the relevant subsection, my lords. An officer of a state tax may exercise the powers and discharge the duties conferred or imposed under this act on any other officer of state tax who is subordinate to him. That means higher officer can exercise the power and discharge the duties which has been assigned to the lower officer, my lords.
Yes.
My lords, here is a case where the lordship may kindly see Annexure A, my lords, page number 13. The respond number 3. Originally in the petitioner's case for the assessment period 2018-19, page 13, my lord.
Yes.
Originally assigned respond number 2 to discharge the duties, my lords. So last time I kindly see, it is issued by the Joint Commissioner who is third respondent. To the second respondent, that is name Parameshwara Gaud, designation DCCT Audit 2 Davangere, who is the second respondent.
Joint Commissioner has
Assigned
it to
the second respondent who is the Deputy Commissioner. That is second respondent.
now the Joint Commissioner is higher.
Higher. Under the delegated power, the Joint Commissioner has got the right to assign to any of the proper officer, my lords.
Under 5.2.
Under section 5.2. Your lordship may kindly see Annexure B, my lords, page 14. The second respondent writes a letter on 9/3/2023 to the third respondent, my lords. That is Joint Commissioner. Stating that ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಈ ಕಚೇರಿಯಲ್ಲಿ ಜಾರಿ ವರದಿಯ ಆಧಾರದ ಮೇಲೆ ಕೇಂದ್ರ ಕಾರ್ಯವ್ಯಾಪ್ತಿಯ ಪ್ರಕರಣಗಳ ಕಾರ್ಯಸೂಚಿಗಳನ್ನು ಸರಕು ಮತ್ತು ಸೇವಾ ತೆರಿಗೆ ಕಾಯ್ದೆ 2017 ಅಧಿನಿಯಮ 73 ಅಡಿ ನೀಡಿರುತ್ತದೆ. ರಾಜ್ಯ ಕಾರ್ಯವ್ಯಾಪ್ತಿಯ ಪ್ರಕರಣಗಳ ಕಾರ್ಯಸೂಚಿಗಳು ಹೆಚ್ಚುತ್ತಿರುವುದರಿಂದ ಕೇಂದ್ರ ಕಾರ್ಯವ್ಯಾಪ್ತಿಯ ಪ್ರಕರಣಗಳ ಕಾರ್ಯಸೂಚಿಗಳನ್ನು ಯಾವುದಾದರೂ ಕಚೇರಿಗಳಿಗೆ ಅಡ್ಜುಡಿಕೇಶನ್ ಕೈಗೊಳ್ಳಲು ಹಸ್ತಾಂತರಿಸಬೇಕೆಂದು ತಮ್ಮಲ್ಲಿ ಕೋರಿಕೊಳ್ಳುತ್ತೇನೆ. That is second respondent requests the third respondent because he is loaded with other works. Please transfer this case, the following case which are finding place in the table, my lords, to some other office. Your lordship may kindly see in the table, serial number 3, the petitioner, my lords.
Yes.
That is for the assessment year 18-19, he has requested. Your lordship may kindly see Annexure C, my lords, page number 15. The Joint Commissioner to the second respondent, that is third respondent to the second respondent, writes a letter. ಮೇಲ್ಕಂಡ ವಿಷಯ ಹಾಗೂ ಉಲ್ಲೇಖಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ತಾವು ಉಲ್ಲೇಖಿತ ಪತ್ರದ ಮೂಲಕ ಈ ಕೆಳಕಂಡ ಕೇಂದ್ರ ವ್ಯಾಪ್ತಿಯ ಪ್ರಕರಣಗಳಲ್ಲಿ ಸೇತಾ ಕಾಯ್ದೆ ಪರಿಚ್ಛೇದ 73 ಅಡಿಯಲ್ಲಿ ನೀಡಿದ ಕಾರ್ಯಸೂಚಿಗಳನ್ನು ಬೇರೆ ಕಚೇರಿಗಳಿಗೆ ಹಸ್ತಾಂತರಿಸಲು ಕೋರಿರುತ್ತೀರಿ. ನಮ್ಮ ಕೋರಿಕೆಯಂತೆ ಸದರಿ ಪ್ರಕರಣಗಳನ್ನು ಈ ಕೆಳಕಂಡಂತೆ ಹಸ್ತಾಂತರಿಸಿದೆ. ಸದರಿ ಪ್ರಕರಣಗಳಿಗೆ ಸಂಬಂಧಿಸಿದ ದಾಖಲೆಗಳನ್ನು ಕಡತದೊಂದಿಗೆ ಪ್ರಕರಣಗಳ ಮುಂದೆ ನಮೂದಿಸಿದ ಕಚೇರಿಗೆ ಕಳುಹಿಸಲು ಸೂಚಿಸಿದೆ. Your lordship may kindly see the table, serial number 6 of the table, my lord.
It goes to the CTO.
Yes, the Joint Commissioner has written a letter to the second respondent stating that the case which has been originally assigned to the Deputy Commissioner has been transferred to the CTO, that is first respondent. On his request, because Joint Commissioner has requested to transfer the case.
No, CTO is a subordinate officer.
Subordinate officer. So your lordship may kindly say an assignment is also issued as per Annexure D. My responsibility is.
No, just one. Now the Joint Commissioner by virtue of annexure C,
Yes, madam.
has sent it to the CTO. CTO is an officer subordinate to the joint.
The deputy commissioner
No, or to the.
and
no,
also the joint commissioner.
Correct. So that is permissible.
No, that is not permissible. Only the, under section 5(2), the higher officer can discharge the duties conferred or imposed on behalf of the subordinate officers. But not vice versa, my lord. The act does not permit that.
Now this, what is the adjudication now to be done?
The
Under
adjudication
section-
order has been passed by the third respondent.
Yes.
My submission to your lordship is it is without jurisdiction because under section 5(2), the adjudicating authority being the CTO, who is subordinate to the deputy commissioner for whom originally there was an assignment. Because under section 5(2), that cannot be done.
It has to go to higher than the deputy commissioner.
Or to the equivalent.
The original assignment is annexure A.
Annexure A, my lords.
Yes, what is?
Lord, under 167, there is a power to delegate by way of a notification. Section 167.
Yes.
The commissioner may, by notification, direct that subject to such conditions, if any, as may be specified in the notification, any power exercisable by any authority or officer under this act may be exercisable also by another authority or officer as may be specified in such notification. Now, my lord, there's a notification, my lord, for that particular year. You just pass it on.
Copy there.
Protect.
Yeah, let him have a look at it. You have a look at it. I'll have it on Tuesday. Counsel for the petty, the revenue files the memo and encloses copy of the order. Same is taken on record. Relist the matter in the same stage on Tuesday.
This is our JDN which has been issued. I will submit on Tuesday.
File objections in this matter, my lords.
May I make a submission? Apologize for seal number 46, a date may be given. Or I go to 48. 46, a date may be given. Serial number 46.
No, if it's stayed, then you wait unless it's going to be disposed of.
Date
Others
is
are
there.
the older matters are there. We're not touching any of the old matters. Let us see. Yes, yes.
My lords, I'll have to file objections in this.
Yes,
my lords. Lordships make.
48.
Please, sir.
Please, my lord.
The honors may grant stay of annexure A to A6.
Would be an interim order of stay of annexure
A to A6.
A to A6 in light of the contention raised. Learned counsel for the revenue request for time to file statement of objections. Is the matter after 3 weeks. Office objections to be complied by them.
Sir, I'll do the needful. Your Honor. Oblige.
The petition challenging the notice under 148 AB, AD order and the subsequent assessment, my lords. My question, my lords, they have assessed me on sale of a particular property. I had written to them stating that I have not sold any property and the property which is sold is not mine at all. I just request my lords to go to page number. Annexure E, page number 23, my lords. It's at the stage of the assessment. Third paragraph, my lords. So far as land bearing number, survey number 49, measuring 1 acre 18 gunta situated so and so. I am not owner. I have not received any consideration amount from
But
the
then
purchase.
this, how you can make such a submission?
My lords, I'll just, there is no, see, they have taken my PAN number and asked me to be a consenting witness. And they have asked me to execute the sale deed. And for a moment, my lords, I'll just take you.
No, but all those matters, how you can tell before the income tax authorities? Now you have, whether you have taken benefit or no, you are a
Sale
part of the-
consideration, I have not received at all, my lords. When I have not received any consideration,
Usually consenting witness is paid some money under the sale deeds.
here nothing is paid, my lords. Just because I had, they wanted some PAN folder. They took my name and execution. And annexure H, my lords, at page 28, it is the conversion order, land conversion order. There is no name of the petitioner here. It's all, it belongs to somebody else.
Now what has happened? 148 ED order, what has happened?
Subsequently, assessment has been made, my lords, treating the entire consideration as my income.
No, but then you take your complete your instructions.
Sushal may be direct.
Huh?
Sushal.
Learned counsel, Shri Sushal is directed to accept notice for the respondents. No, but these all are factual matters. How we can intervene at this stage? You have
My
to go
lords,
in a
I have not been served with the notice at all because I was not an assessee. It
ex
was,
parte proceedings.
it's ex parte proceedings.
Lords, if it has to go back, my lords, next week will appear.
List
We'll
the
get
matter.
instruction.
They would, I'll grant interim order, let it come in preliminary hearing list.
Please.
There would be a stay of
Annexure J, my lords,
annexure J.
J,
List the
and
matter
penalty notices, my lords.
and proceedings.
J, L, L1, L2, my lords.
J, L, L1 and L2. List the matter in the interim order till the next date. List the matter in the preliminary hearing list on 16th. Yes. Office objections to be complied with.
Lords, office objections, sir, it is complied. They are asking for the originals of the sale deed and the conversion order, which I do not have.
Office objection is overruled in light of the submission made. Next.
Lords, 50, my lords, it's a matter of remand. Lordships may kindly have it next Tuesday, my lords, I'll have to get.
List the matter in the same stage on next Tuesday. Yes, next. Office of. Yes. ಇನ್ನೂ ಜಾಸ್ತಿ ಇದೆ. ಇದಾದ್ಮೇಲೆ ನೋಡೋಣ ಅದು ಆಗಲ್ಲ ಇದು ಆಗಲ್ಲ. Yes.
Page 68, your lordship.
Yes.
Here, your lordship, the para C, your lordship.
Yes.
Issue a writ of mandamus holding the act of secondment of the employees from the overseas entity is not taxable under GST and does not amount to import of services by the petitioner. Now, what happens, your lordship, we take expats for the purpose of various specialized functions. Now, we pay them the salaries in the country, your lordship. And they are also entitled for social security benefits.
Just one minute. Who appears?
I appear for this.
Yes.
So that social security benefits I pay to the company abroad, which in turn pays to the government. So there'll be a zero margin as far as the company is concerned, your lordship.
Now, whether this amounts to an import of service, number one. If it amounts to an import of service, what is the value on which tax has to be paid? Because the value will ultimately be zero. If I give salary here, and then if I pay him the social security amount, he in turn completely pays it at a cost with no margin. Then there will be no value at all. Similar matters, Your Lordship, my lords have granted stay. Page 330. Your Lordship. 333 onwards, Your Lordship. 333 is the order of the Delhi High Court.
337.
At 335, Your Lordship, they refer to the Karnataka High Court and Punjab High Court orders. 337, Your Lordship, is this court's order.
Lord Counsel, so it's covered, is it?
More on the stay orders, yes, Your Lordship. Now what they have done, Your Lordship, is, Your Lordship, be aware, the government has now issued a series of well-intentioned circulars. About 16 circulars have been issued. One of the circular, Your Lordship, specifically says that where I'm entitled for an input credit, entirely input credit, I'll be entitled. If I pay the tax, I'll get the input credit. Then even if a service is rendered by the overseas entity, but no invoice is raised, it can be considered as a zero value, and therefore accordingly the issues can be raised. Now that the circular seems to cover that also, Your Lordship. So in a situation of secondment, Your Lordship, where no margin is there,
Hearing on
can be
behalf of the petitioner submits the identical legal question raised has been considered in WP 23915 of 2023 and interim order has been passed. Interim order passed in WP 23915 of 2023 on 2/11/2023 reads as follows.
Who was issued annexure here?
Service का नाम क्या है?
Assistant Commissioner.
Then whom have you made a party?
Assistant Commissioner. Enforcement.
Accordingly, there would be an interim order in the present matter also. And there would be stay of
Your Lordship, of annexure A,
annexure A
page 72.
list along with
Well, it's a small correction in the petition. The advocate on record may be permitted to correct the name of the respondent.
the petitioners permitted to.
It should actually be
to
Assistant Commissioner of
rectify
Commercial Taxes, Enforcement, 13 South
by
Zone,
the
Bangalore.
description of respondent number.
No, instead of additional commissioner, I think the mistake
Which,
is because
which
the
respondent?
address shows as office of the additional commissioner, but the notice has been issued by Assistant Commissioner of Commercial Taxes at page 114, Balaj. Assistant Commissioner of Commercial Taxes, Enforcement, 13 South Zone, Bangalore.
No, correct. So he's permitted to rectify the description of respondent number.
Sole respondent.
The sole respondent.
Great.
Otherwise, Malaj, there will be a complication in communicating the interim order.
Very good. Dates.
They'll say it is not binding.
Other matters are not likely to reach. There's some parted matter. Dates will be given by the court officer. In those matters of preliminary hearing, most of the matters we have given stay orders. Those matters where no stay orders are given, those matters will be repeated at the shortest available date that you please make a mention to the court officer. In those matters where no interim order is given, shortest available date will be given.
The same stage.
Yes, yes. Same stage.
Mention serial number 52, which is the next matter. My request is, my lords, that matter probably, if I am able to persuade my lords, subject to my learned friends' agreement also, will have to be remanded back because the assessment order is passed for my all India turnover, as opposed to he should have issued me assessment only for Karnataka state. So my lords, I am requesting maybe 2:30 sometime in the next week, Monday or Tuesday.
No, let it come in the same stage, it will reach, and on that day I'll take it up. I'll give the shortest available date.
The next week, my lord, some date in next week.
Dates will be given by the.
My lord, serial number 76. It is only a formal application for implement of the trustees of the petitioner number 1 trust.
See, now, if I take up now, I will not be able to take
Obligations.
the part heard.
Obligations.
So the court officer will give dates. It will come in the same stage.
Lord, 77, I had made a mention, Lord. It's there in the B group, but there's a interim application for consideration of interim prayer, my Lord.
ಅದನ್ನ orders
It's
list.
taken up, Lord.
ಅದನ್ನ orders list ಅಲ್ಲ. On orders list it will come.
Your Lordship, serial number
My lord.
59, Your Lordship, my account has been attached, Your Lordship, for the recovery of the impugned order, for the demand, Your Lordship. With
If shortest available date, you make a request to the court office.
My lords, item 66 is listed under preliminary hearing. It is a fresh matter. If it can be directed to be listed under fresh matter, I will take the date from him.
It hasn't come once also, is it?
No, it has not.
The fresh matters.
Item 66. I'll take the date from.
My lords, interim orders will be extended.
Yes, wherever interim orders there, it will stand extended. ತಗೊಂಡ್ಬಿಟ್ಟು ಮಾತಾಡ್ ನಾ. 82 is 1 to 2. We have the DBM. We have the 84. Now, what is 84 and what is 83?
84 was something that was heard last week.
Huh?
84, Your Lordship, is the matter which my lords have heard me that day.
My lord, that is regarding intermediary or export service, my lord. My lord, this matter I had informed my lord. There is a redistribution of files, my lord. Kindly 4 weeks time may be granted. I have to complete the pleadings also.
84.
What Your Lordship is a matter of concern. This 84, Your Lordship, is 1.5 years, Your Lordship. This first writ petition was filed about 1.5 years before.
Just 1 minute, just. Yes.
In this Amazon writ batch, Your Lordship, about 6 matters are there. The first writ petition, Your Lordship, was filed in March 2023. Then my lords had given a stay somewhere in April or something. Thereafter, after gap, Your Lordship, as and when they pass an order, we used to file the for hearing. When it came upon 12th, Your Lordship, 12th of June, that's when I pointed out, Your Lordship, that this series of matters are getting accumulated. About 55 crores is being denied. Therefore, my lords can hear all these matters, and now that there is a circular that has been issued, so therefore that needs to be seen. I pointed out, Your Lordship, that one, as far as the legal position is concerned, there are circulars and decisions on that. As far as the facts are concerned, my lords have to look into the agreements in each matter. So we had to explain the facts in each matter and get into it. My lords posted it on 26th. Then that's when last time, Your Lordship, I had argued on the facts, on the legal position and all that. And my lords have posted it today. Now we are being told, Your Lordship, that the matter is being reallotted. And subsequently, Your Lordship, series of notices on all this. Somewhere, Your Lordship, there has to be an accountability to the court. There has to be, Your Lordship, fairness to the court. Whether they are fair to the assessee is a different point. But you can't have matters being handled like this before the court. After 1.5 years, today we are being told matter is reallotted. Somebody else is to see. How did they know? How did notice get issued earlier? How did they take notice? What did they do with that notice? Somewhere, Your Lordship, these things have to be seen. I only wanted to place that before my lords, Your Lordship.
Whenever the word refund is mentioned, they get chills and fever.
As a legally entitled refund, Your Lordship.
Not only. Once they're only used to taking.
No, not used to giving.
Giving, it's very difficult.
To an extent, refund. To an extent, refund is okay, my lord.
On refund, 2020 is the first petition is still pending. There are 6 of those petitions can also, my lords had posted it for 230.
Yes.
Those could be posted along with, need not be tagged, it could be posted along with this as your lordships would direct. Can I give those numbers? I think I had given those numbers to you.
So
It's already there in today's list.
Relist. So and so. Now this has to be tagged along with this.
Tagged or I leave it to your
No,
lordships.
what
Whatever your lordships.
my suggestion would be, Your Lordship, my lords can hear each these matters separately. Because
Separate.
the arguments, Your Lordship, would depend on the agreements that are on record. Some agreements, Your Lordship, will have different wordings and all that. So each agreement should not influence the other one.
Each SSC will have a
The
separate.
other thing, my lord, is we will try as far as possible. Once Mr. Shivdas finishes his arguments, to adopt this and only point out the differences in our agreement.
Relist. 1 to 3.3. On the same day on which WP 13007 of 2024 and connected matters are listed.
There are 6 petitions.
Yes, yes. These matters, serial number 84.
4 weeks, my lord, I'll complete pleadings. I'll give the copies to them and then I'll move the matter.
In fact, one of the matters.
Because it
finished
is 2024 matter to 23, I'll just,
23 is the first.
24,
one,
yes,
sir.
yes, I agree.
Let's be clear also on that.
Yes, yes.
The lords can have it on 16th, your lordship. Or
16th,
23rd, your lordship.
It cannot, somewhere in the next month, my lord.
No,
Because
no.
I have to complete the pleadings, that is.
23rd.
Yes,
23rd.
24th, my lord.
and these are cases. your
Because
lordship,
pleadings have to be completed, my lord, that is why, my lord.
24.
these are
I'll try,
cases-
my lord. I'll try
These
to
are
complete the
case-
pleadings.
These are cases, your lordship, where orders are passed in these cases. Not constitutional validity. Orders are self-explanatory. They can't add a counter which increases what is there in the order. So therefore, your lordship, counter is more in the nature of supplementing what is there in the order.
Let us see.
Yes, sir. 23rd, your lordship.
24th.
24th,
230.
in the same stage. Parted news.
Lordship's permission, may I make one submission in
Yes.
serial number 71? We withdrawing the petition. I've submitted the memo for withdrawal. The officer has considered my submissions, most of my submissions, and concluded the proceeding. I seek leave of this honorable court to withdraw and liberty to challenge the proceeding.
Counsel for the petitioner files a memo which reads as hereunder. In light of the same, petition is dismissed as withdrawn. Liberty to seek for remedy insofar as unaddressed grievances is reserved.
My lords, matter number 74, if I could make a kind submission, my lords. My lords, I had to file my amendment application and the amended petition, my lords, today. And my lords, we need an interim order because the petition is,
We listed in the shortest available date.
my lords, kindly tomorrow, my lords.
Noted, noted. Yes, yes. Togo parted to end this.
Grateful, my lord.
80, 83, no? 82, no? 83. Yeah. 1 by 1. Huh? Yes. The meeting is.
With the Lord's kindly, my lords. Serial number 83. You finish this in the.
First 82.
82, 83, Mr. Shivdas only has to argue the matter. It is for main arguments. We could start it some other day, my lords.
No, today I'll have to rise correctly at 4:45. So I think 82 will finish today.
That is the reason I'm asking. Then it's senior, if he can.
No, let
Some other
let those hopes remain till 4:45.
I also thought so, yeah.
Yes.
This is the case, your lordship, where we export services, your lordship. We claim refund of the input tax credit, your lordship. Now, what happens, your lordship, when we file the refund claim? We file, Your Lordship, along with the documents. Originally, earlier, Your Lordship, we used to file what is called the bank reconciliation certificates.
VAT.
Bank reconciliation certificates, BRCs or FIRCs. Foreign inward remittance certificates. Your Lordship. Over somewhere, Your Lordship, somewhere 2016-17, the Reserve Bank, Your Lordship, stopped issuing physical copies of the FIRCs. So they have only the online copies. But they'll give physical copies if we request for it. But there has to be a separate request. So what happened, Your Lordship, along with the refund application, we filed all the documents and then a statement indicating that these are the FIRCs which I have got. These are the amounts. And this is in terms of this export invoices that have been raised. So after I file, Your Lordship, along with the refund applications, the officer issues a show cause notice raising certain objections. I file my reply to the show cause notice. The officer passes an order, Your Lordship, granting me a refund. He looks into all these documents. He looks into my statement of foreign inward remittance certificate. I file a chartered accountant certificate explaining, Your Lordship, which FIRC relates to what, because one FIRC will relate to a number of invoices. So we filed a chartered accountant certificate correlating the whole thing. And then, Your Lordship, he looked at me agreements I have. I have an agreement with a foreign company in terms of which I'm supposed to develop software and then I'm supposed to give it to, Your Lordship, to the foreign company. So I'm supposed to give so I filed the asked for the agreement, we filed the agreements, etc. So once that was done, Your Lordship, the officer looked at my agreements, looked at the various documents and sanctioned as the refund order. We'll also have a look at this refund. Page 196, Your Lordship.
Yes.
Page 196, Your Lordship. Refund sanction order. Same order, Your Lordship, for all the
Who's the other side?
periods.
Yes. Yes.
Now, once we filed all the claims, Your Lordship, we looks at my documents. We'll also come to page 199. Page 199. Each of the objections, Your Lordship, he examines. Para 2, Your Lordship. Page 199, 1.4, para 2. The client has submitted the export invoices which have been addressed to their client located outside India.
You're reading at page?
Page 199.
Yes.
On verification of the confirmation of.
No, which paragraph?
On the top, Your Lordship, para 2. Page 199, para 2, Your Lordship.
The SSC has submitted export invoice.
Absolutely. SSC has submitted the export invoices which have been addressed to their client located outside India. On verification of the confirmation of foreign inward remittance provided by the Bank of America, it is found that the claimants have exported services to their customer located outside India and received the remittance in the registered premises as mentioned in GST registration. Claimant is located in the taxable territory and the recipient of service is located outside India and realization has occurred. Whether the conditions specified in section 54 has been satisfied, my lords will see. He examines all this last line. Hence, the same is taken as receipt of date of application, complete in all respects as per section 54(7) of CGST Act. Third, whether the conditions specified in Rule 89 has been satisfied. Para 4.1 here. The claimant has submitted the refund claim for the period April 19 to September 19 in GST RFD 01. He has submitted, I'll also kindly note this, a statement 3A, GSTR and 2A invoices which are not part of 2A, relevant export invoices, and a CA certificate certified foreign inward remittance advice for the claim period. The claimant has debited total refund claim in terms of 89.3. In terms of 89.2C, the claimant has to submit EBRC or FIRC in case of export of services to prove that the export proceeds have been realized. In the instant case, the claimant has not submitted EBRC FIRC due to discontinuation of the issuance of physical copy of FIRC by authorized dealer bank in effect of circular dated so and so. However, the claimant has submitted details of the invoice raised and foreign inward remittance advice. The foreign inward remittance is issued to Bank of America is the proof of receipt for payment of export advice, export of service for the relevant period as per section 26. As per the provision of IGST Act 26, realization of the payment is essential criteria for sanctioning of the refund for export of zero rated supply. From the verification of the taxpayer submission of FIRC, it is clear taxpayer realized the amount as per section 26. Hence, taxpayer submission of foreign inward remittance advice has been taken as the proof for the realization of export proceeds to expedite the process of sanctioning of refund within the time period specified in the provisions of the CGST Act. Then Your Lordship, whether ITC is available, that he works it out and gives me the relief, Your Lordship. And page 203, he sanctions me the refund here. I hereby sanction an amount of 18 crores 17 lakhs. Amount of so and so is to be. I hold ITC to the extent of 64 lakhs availed as eligible as irregular for the reasons described. So after this order was passed, Your Lordship, the revenue files an appeal to the Commissioner Appeals. Their case is that what has been given by the SSC in this case is only a statement. The actual EBRCs have not been given, and therefore the refund claim should not have been sanctioned. That, Your Lordship, is the appeal filed by the department. Which, Your Lordship, the impugned order which we have challenged narrates, Your Lordship. Page 97. This is the impugned order.
Annexure E.
97, Your Lordship.
Annexure E starts at page 95.
95. Yes, that's the impugned order. That's the order we have challenged. Page 97, Your Lordship.
Yes.
See, para 2 and para 3. Para 2, Mr. So-and-so have filed a refund claims for the refund of unutilized input tax credit on account of zero rated supplies. The Assistant Commissioner sanctioned the amount of rupees so-and-so.
You're reading at para?
Para 2, Your Lordship, is where he narrates how much claim I have filed.
Yes.
Para 3, Your Lordship, the Assistant Commissioner sanctioned the amount and rejected the amount of rupees so-and-so, while orders dated so-and-so. However, on examination of the said order, in view of the provisions of subsection 2 of section 107, it was observed inter alia that the respondent has not submitted EBRC FIRC, which is mandated under Rule 89(2)C, read with circular, that one of the conditions while defining export of services under section 2(6) is that the payment for service received by the supplier of service in convertible foreign exchange, that the services exported by the taxpayer cannot be said to have been realized in convertible foreign exchange, as the EBRC have not been submitted along with the refund claim. My Lords will kindly note that this is their case, Your Lordship. The EBRC FIRCs have not been submitted along with the refund claim, which is one of the mandatory conditions for consideration as export of service. And hence, the payment for service can be said to have not been received by the supplier of service in convertible foreign exchange. Therefore, the impugned services do not qualify as export of services in as much as place of supply of services in the taxable territory, which is in contravention of section 264. That even in the FIR advises, the location of beneficiary is mentioned as Gurgaon, Haryana, which is different from the supplier's location in Bangalore. Therefore, the chartered accountant certificate does not hold good as per explanation 1. wherein it is stated that a person has an establishment in a state or union territory and any other establishment which shall be treated as establishments of distinct persons. And in several instances in the FIRC advices, it is mentioned the purpose of remittance as against intercompany receipt. It is not the same as remittance for having made zero-rated supplies. That the invoice is raised to the respondent, it is mentioned that the payments are to be made in Bank of America, Delhi account, whereas the FIRC advice shows to the account which does not pertain to the respondent. This, my lords, will note. We have clarified this entire position. What happens, your lordship, is the amount will come to one account in Delhi, your lordship. We have an office in Delhi. We have the center in Bangalore. So from once it comes to Delhi, your lordship, it comes to the automatically to the account in Bangalore. So the amount will see as if it is received in Delhi. Thereafter, the amount will get shifted to Bangalore. This we clarified in terms of a chartered accountant certificate where we correlated every FIRC with the export invoices. That is how the order, the assistant commissioner who passed the order, examined it and gave us the refund. Now, my lords will see. In view of the above, the principal commissioner of Central Tax Bangalore, while reviewing, has issued review order authorization, authorizing the assistant commissioner to file an appeal. Thereafter, your lordship, this order and the appeal has been filed. The hearing took place, your lordship, and by this time we were able to get, your lordship, the EBRCs directly from the bank itself. So once we filed that, your lordship, when the appeal was pending before the first appellate authority, we gave them the actual EBRC also. We gave initially the statement, your lordship. Later on, we gave the EBRC also. Now that the Commissioner Appeals looks at those EBRCs, your lordship, and then he says, your lords will see at page 102. Page 102, your lordship, about 10-11 lines from the top. After that highlighted portion, I find that the respondent admittedly has not submitted bank realization certificates or foreign inward remittance certificate in the refund application filed by them to indicate proof of receipt of the entire foreign exchange proceeds billed by them. I find that as per serial number 1 of annexure A of circular dated so on. So the impugned claim needs to be filed with the statement 3A under 89(4) along with the support documents in case of export of services which has not been complied with. On these grounds itself, I find impugned refund claim is not admissible as it has been filed in violation and without compliance with sections 54(1) and 54(4) of the CGST read with rule 89(2)C. We'll also kindly see the provision and the rule that is extracted by the commissioner himself. Kindly see this.
No, but subsequently you said you have given
We
it.
have filed it. We have filed it. That, my lords, you see. Page 317. Para A.3. Para 17, your lordship, my lordship.
Yes.
The respondent wishes to submit your good self that post sanctioning of the refund claims, the appellant requested for submission of the EBRC against the FIRAs already submitted. Thus, upon request, the copies of the BIRCs were also submitted by email dated so and so. Copies of the emails have been attached as annexure E. The respondent is again submitting to your good self copy of EBRC against export invoices along with the list of export invoices correlating with so and so. Copy of the same is attached herewith. Based on our above submissions, it is sufficiently clear the respondent have submitted all the BRCs. The respondent have duly received the convertible foreign currency against the export supplies and have submitted all necessary documents as required under the provisions of law read with circular 125 to substantiate the receipt of foreign currency. the refund claims filed by the company is true and correct in all respects. We also see para 21 also, Your Lordship. The respondents wish to mention that during the personal hearing held on 25th April 2022, your good self has mentioned that though the copies of EBRCs were submitted post sanctioning of refund upon the appellant's request, but the same were not submitted at the time and during the processing of refund claim. Therefore, the refund granted to the respondent is being questioned on this. So their only case, Your Lordship, is that EBRCs were not filed along with the refund claim. The adjudicating authority, Your Lordship, looks at the statement given by me, is satisfying himself that the refund, the amount indeed has been received. There is a complete correlation and sanctions be the refund. Ultimately, Your Lordship, what is required is whether I have received the foreign currency. There is no other dispute. Export invoices are there. The fact that I have rendered services is not in dispute. I have to receive foreign currency, Your Lordship, is a requirement. I have received in foreign currency, there is no dispute. The only question, I have not given the EBRC along with the refund claim. The adjudicating authority looks at my refund claim, looks at the statement and satisfies himself, sanctions the claim. There's nothing to say satisfaction is erroneous. They file an appeal saying that you have not given the EBRCs along with the refund claim. And once I produce those EBRCs to the first appellate authority, what the original authority can do, Your Lordship, along with the refund claim, the appellate authority also can do. I have given the EBRCs to him and he says that yes, now you have given to us, but you did not give it earlier when you filed the refund claim, and therefore the refund claim is to be rejected. That's the only ground, Your Lordship, in the entire order. We'll also just have a look at the provisions, Your Lordship, which is there at page 100. Yes, reproduced it.
Yes. Yes.
Page 100, Your Lordship. Section 54. Any person claiming refund of, my lords have it, Your Lordship, down below. Any person claiming refund of any tax and interest, if any paid on such tax or any other amount paid by him, we make an application before the expiry of 2 years from the relevant date in such form and manner as prescribed. The application shall be accompanied by such documentary evidence, Your Lordship, to establish that a refund is due to the applicant, and such documentary or other evidence, including the documents referred to in section 33, as the applicant may furnish to establish that the amount of tax and interest, if any, paid on such tax or any other amount paid in relation to which such refund is claimed was collected from or paid by him, and the incidence of such tax and interest has not been paid or any other person. My lords will see Rule 89. As per Rule 89 of CGST rules, application for refund of tax, my lords will see 89(1). Any person except the persons covered under notification may file an application electronically in form GST RFP 01 through the common portal. My lords will see C, a statement containing the number and the date of invoices and the relevant bank realization certificates or foreign inward remittances certificate, as the case may be, in a case where the refund is an account of export of services. So I should file a statement, Your Lordship, containing the date, number and date of invoices and the relevant bank realization certificates or FIRCs, as the case may be, in a case where the refund is an account of export of services. So I filed a statement. The statement gives the reference, Your Lordship, to the EBRCs, which I have got online. I have filed it along with my refund application. Officer looks at it, is satisfied that these are sufficient enough evidences to show I have received the foreign currency. Now, the moment they file an appeal, I get these EBRCs, go to the first appellate authority, give him the EBRCs also. He says, yes, now you have given it to me, but you did not give it earlier when you filed the refund claim, and therefore your refund claim, you don't satisfy the purpose.
That is the only ground.
There is no other ground here. Anywhere. We'll also see the page over. There is one, your lordship, on the fact that your, the FIRC, the reference, your lordship, is to Delhi, and then thereafter it has not come to Bangalore, etc. We gave a complete correlation of how the whole thing operates. That correlation also, your lordship, my lordship can see, page 138 here. Page 138 here. This is a CS certificate. This for one period, your lordship. April 18 to September 18. Like this for all the periods, CS certificate is given. Your lordship will see there are two. That the company have represented and confirmed to us, and we are related to say that NSN, which is Nokia Solutions Networks, have a centralized treasury function from some entities of NSN Group operated by Nokia Finance. Nokia Finance monthly collects intercompany payable and receivables from the participating NSN Group companies, and thereafter pays to / receives from the companies who have raised invoices by bank transfer. In view of the above, as a remittance is done by Nokia Finance to the respective NSN entities' bank account, the FIRCs are received from Nokia Finance and not from respective NSN intercompany. Accordingly, the company has mapped the export invoices with the FIRC detail received from Nokia Finance. Based on this, there are certain transactions which are mapped basis the FIRC details, netting off of details shared by Global Finance in respect of realization of FIRCs against and the export invoices. Thus, there could be a difference on account of credit as mentioned in the FIRC and the account of realization presented by the company. That is, the amount of unit at Bangalore, Karnataka may have remitted to office in Delhi as a part of netting off of all payments made. That the company has represented and confirmed to us that the said amount, part of amount has been utilized only for Bangalore location of NSN and not used in any other account location of the company. Page 140, your lordship, from page 140 to 146 is a complete correlation that has been found. Therefore, our submission, your lordship, this is the only ground that is raised either in the show cause raised to the ground, your lordship, that we have not given the documents. We have not given the agreements. The adjudicate, we gave all the agreements, etc. The adjudicating authority looks into all this, is satisfied, sanctions a refund to me. They file an appeal only on the ground, your lordship, that the EBRCs were not filed. The commissioner, when the matters before commissioner appeals, I produce EBRC before him. He says there's no point in giving it to me. You did not give it when you filed the refund claim, and therefore I will reject your refund. That's the only ground, your lordship, as far as these orders are concerned. Now, there's one point I wanted to highlight, your lordship. My lords could take the statement of objections given by the department.
Tomorrow at 2:30.
May I request on Monday, tomorrow something. May I request on Monday? Subject to signing. In college, tomorrow I need to be.
Which
Monday.
day?
Monday,
Monday, I'm not there.
Tuesday.
Tuesday, Wednesday, 3 days I'm not there. That's only.
Some incomes tomorrow. I'm to be in the college.
Friday also we can take, if it's convenient to him, Friday also we can take.
Thursday, next Thursday.
Tomorrow is Thursday.
Next Thursday. Nada illa. Tomorrow and after I'm in the college.
Next Thursday at 2:30.
Very well.
But you just examine. that one prima facie, whatever your client says is different. No, prima facie, once they produce those, that one, the remaining one will examine.
Eligibility, my lord. I did not want to interrupt since the senior was going on. Lord, whether it qualifies to be an export.
That was never a ground raised, your
No,
lordship,
no.
the show cause.
That will point out. Whether export, that is, whether the.
But let's look at your appeal grounds. Let's look at your appeal. Appeal memo is there.
Yes,
Appeal memo,
filed as part of
the order is there, my lord. The appeal memo is not there.
appeal memo is filed here. It's part of the volume itself.
Is the matter for further hearing at 2:30 on
Thursday,
next
11th.
Thursday. Okay, on 11.
Next, that's my.
2:30 further here.
ಅದೇಮೋ ನಾಳೆ ಮುಂಜಾನೆ ನಾಳೆ ಹಾಕ್ಸ್ಬಿಡ್ತೀರಲ್ಲ.
What else, sir? What else, sir? Serial number. Got it? What else, sir? Serial number 56, sir. Mandamus ಅದು mandamus ಅದಕ್ಕೋಸ್ಕರ ಅದಕ್ಕೋಸ್ಕರ ಫ್ಯೂಚರ್ ಅನ್ಸ ಫಂಕ್ಷನ್ ಇದೆ
ಮೆಮೊ ನಾಳೆ ಬರುತ್ತಲ್ಲ ಆಗ್ಲೇ ಮೆಮೊ ಕೊಟ್ಟು ಇವತ್ತು ನಾಡ್ದಕ್ಕೆ ಸರ್. ಬರೋ ಆಯ್ತು.
ಇಲ್ಲ ಎಲ್ ಟಿ ಅಂತ ಇದೆ ಸರ್ ನೋಡಿದ್ರೆ ಎಲ್ಲ ಎಚ್ ಡಿ ಅಂತ ಇರೋದೆಲ್ಲ ಎತ್ತಿದ್ದೀನಿ. ಇವ್ರು ಬರ್ದಿದ್ದಾರೆ ಸೊ ಅದಕ್ಕೆ ಇಟ್ಟೆ.
Twenty-third. 23rd, 2:30, no? 2:30, sir. Thank you.
PLG ಅವಾಗಲೇ ಬಂದು ಕೇಳಿದ. Sixteen.
Back it up on it. Very good. He's kept it as a file. I've made my marks in the file. Searching for the file is not.
File argue ಮಾಡಿರೋದು matter ಫೈಲ್ ಕೊಡ್ತಿದ್ದಾರೆ.
ಅದೇ ಅವರು ಮೆಮೋ ಮಾಡಿ ನಮ್ಮ ಫೈಲು ಎತ್ತಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಲ್ಲಿಂದ. We will deal only with the synopsis compared. Thank you.